Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please. Verbis Latino. I didn't ask you to interrupt me.
Is that correct?
Oh, for crumb's sake.
Good afternoon. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Wednesday afternoon, hump day. It's hump day afternoon. You're halfway through the work week right now, and we're officially on the downhill side as well. That's a good thing. So, welcome. Also, got to say welcome to Kim R16, who was first in chat again. Congratulations, Kim. Your promptness and punctuality on this live stream has also garnered you a punishment. Everything up here related worldwide is your responsibility. Still. So you can just keep on doing what you're doing. We're going to be headed back to court with Judge Raquel West in this Texas v. Freeman case. We can see a couple people are in court. We're just waiting for the judge to step in. Got just a few minutes. Jury will be in shortly. The state has arrested defense, and the state have been working through some of the jury instructions, the charge. We hope that's already done and solved. We're going to find out if the defense puts on any case whatsoever, or if this goes straight to verdict watch. So we'll see what happens here in just a moment, as defense did let us know right before the lunch break that the defendant would not be testifying in his own defense. All right. Hey there, Lois. Welcome. Red Pen, I see you there. Saw Amber in chat as well. Josh is out and about. Probably got a few lurkers in the house as far as the mods go. I happened to open my phone, and here you are, Kim Mac. Yes, that was how it started. Yes, there was a portal, for sure. All right, we are, I think we're live. Did you really just add? No, I said I saw you. I saw you here. I saw you. I told you I was looking for a house that has rocks. Well, my wife found a house with rocks, and I hate it. It's terrible. I don't even know what state it's in. But the thing I don't like about it is it has the hearth, the fireplace hearth that I had growing up. And I remember how many times I whacked my foot or my toe or my head or my elbow on that thing. And it's like, no, we can't do that. I can't live there for that very reason. But she gets to choose. Not that one. I'm going to exercise my veto power. And I realized she did well. It was in the right price range. Had the right number of square feet. It had a full acre of yard, which is a lot of lawn care if you have a lot of trees. But if it's all just grass, then it's okay. And it had rock, like a garden with rocks in it. And then it had that fireplace. Wrong rocks. How many vetoes do you get? Well, one per house, I think is the fair number. Of course, she's gonna win if this ever goes to a rock garden. You have veto power after buying your current house sight unseen. She loves me. What can I say? Yeah. I was just impressed that she found a house that like matched everything I told her I was looking for, and then she showed it to me, and I'm like, I don't want that one. So we haven't landed on a state yet. No, we're here still in North Carolina. But the idea is to get closer to family, and because we're the furthest east, they're all west. So the idea is to go west, and preferably far enough that it will actually make a difference in visiting. So at least a day or two, right? At least a day or two west. Florida's a good state, but not west enough. If you could move Florida, Lois, I would be on board. for part of that. But we'll see. Just pie in the sky right now. All right, I am seeing defense is present, defense is there, state's there. Looks like they might be just waiting on the judge, who's got about 4 more minutes before she's late. Keep touting the Great Midwest. You're in the Iowa camp, right? Red Pen? Hopefully I didn't remember that wrong. I get it mixed up in my head. Then you're going to be in the wrong time zone for me. Susie Adams, sorry. I'm going to be in the wrong time zone for somebody. But I don't know. If I go central, get a couple goats or donkeys if you're getting land. That's what I told my wife yesterday. She's like, I don't want a huge... She did not say it like that. That's why I stopped. She was very calm and clear. And she said, I don't want a huge yard. You already hate taking care of ours. Why would you want a bigger one? She wasn't sold on that. The goats argument did not fly. It's affordable, nice, and we have lots of rocks. Okay, I need to be more specific about the rocks. I need variety. Now, I'm not necessarily looking for gemstone quality topaz and aquamarine or jasper or diamond or anything. I'm not trying to strike it rich by turning over spades full of dirt in the garden. Although that would be nice if it did happen. That's not one of the parameters I have. I'm too scared of tornadoes to go with a manufactured home. Anyway, let's see. I forgot where I was going. I need a variety. I like the agates. I need variety. I need rocks to roll down from the mountains in the rivers to my house. That'd be preferably how it happens. Lots of rocks. We have all the rocks here. The thing is, growing up, I hated the rocks. I need your house that can accommodate is 8 billion cables. Yeah. The rocks were glacially deposited. Oh, you good. Arkansas has the diamond craters. That's cool, but I think they're just limestone now. Does Arkansas have a variety of rock? Kansas, I think, only has corn. They might have rocks, but it's underneath the dust layer on the top. Western South Dakota, low tax, a variety of rocks. This stood out to me. You buried the lead a little bit, AZ. You need to start with that. So Western South Dakota has a variety of rocks, low taxes, lots of history, beautiful country, and mild winters. Oh, and then there's also the has to be homeschool friendly state. Idaho's the gem state. They are. There's an option. Wyoming has a lot as well, like tons. Iowa's homeschool friendly. Yeah, define mild winters. I've always heard the Dakotas were. Isn't that where they filmed Grumpy Old Men? With the ice fishing thing? Ohio has it all, apparently. I'll tell Mrs. Ari, we need to look at Ohio. All right, you're late, says Kim. You're late because you're the internet owner, but you're also early for court. The judge isn't here yet. I believe the defendant is out pacing the courtroom again, as he does. He must be free on bond. Lived in North Dakota for a year. 2 days after moving there from L.A., it was -30. My Cajun blood was not ready. That was just your welcoming party. After that, it probably got mild. If you like swords, I hear New Mexico is exciting. Oh, man. Or do I like S words? Never mind. Yeah, swords. Western South Dakota has mild winters, not the prairie on the eastern side. Hold for a minute while I pull up my map of the church. Hang on, Apple just verified me. Got it. It's done. It took forever. And yes, I had to email them my driver's license, which sounds like it's a shady thing, but you know. Devices. Boom. Yes, I've got a stack of iPads I need to configure now. Not for me, for other people. All right, let's see. Born and raised in Iowa, cold and snowing. Grew up in Davenport, Iowa. Is that where the Music Man was? No, that was Indiana. Gary, Indiana. Oh, right. What does verification do for Apple products? I'm setting up an organizational account, a business account with Apple for an organization I volunteer at, church, and I am tech support for Eastern North Carolina. Everything from Rocky Mount down to Kinston, the whole almost everything but the Outer Banks. They're sort of separate, and so I'm configuring Apple devices for people who need them. So they've purchased them. They've purchased them. They sent them to me. I've got a stack of iPads that I can't configure with business accounts, so we can manage them and monitor them and make sure they don't go missing and things like that, and push out updates for our apps and everything. I needed a business account to do that, and it's taken a month to get it done. And today during lunch, they approved me. All right, so why are you wanting to move? Just for a change. We didn't know why. We just felt it was right. We were supposed to move out here. That's just sort of like we felt guided by a higher power, but not knowing the reason, if that makes sense. And so we moved, and it was amazing. We love it, but now we feel that we need to move again. So still no reason. Still haven't figured out the last one. All right. Do you have a list of no-way states? Mrs. R.A. does, and Hawaii and Alaska are on them, which were the top of my list. So I figure I've already given quite a bit of concessions on this. All right. I'm a grandpa now. I'm a grandpa. Did I not tell you, Josh? I'm a grandpa. I've got a granddaughter in Idaho that we need to get closer to so we can babysit and see on a regular basis. Anyway, that's one of the reasons why we're moving. Maybe that'll convince her on Alaska and Hawaii. Could. States like Florida, Alaska, and Hawaii have the most lenient extradition environments for out-of-state misdemeanor warrants. Greeners, stop! As they typically refuse to extradite for offenses that are not felonies. All right. This wasn't on my. I'll put a little note with an asterisk on it, but I don't think that's going to factor in. I don't think she's like, yeah, what's their extradition policy? This isn't like Italy or Mexico where they're like, yeah, we've got your felon. We've got the guy that you've been hunting for, and we're not going to return him unless you promise not to try him for with the death. They're doing it right now. Italy has a guy we want for the death penalty in Texas, and they're like, we won't send him to you unless you guarantee you won't seek the death penalty. So it's fun. Amber, he's doing that. He's doing that. Man, we missed you, Greeners. We're good to have you back right now. Let's see. How do you even search for that? What would you put in Google to find that? What's the best criminal-friendly states? We Italians like to do it ourselves. Yeah. I binged it. Bingo's the internet. All right. We need the defendant to get back up in his chair because time's coming. That clock's ticking. Want to hear the defense rest? I think that's the next move only because they've had nobody in court. I just don't think they have. I mean, I realize sequestration, the rule's been invoked, and they couldn't be there anyway. But we haven't seen anyone pay attention to this trial at all. If you're not a juror or a lawyer or the defendant, you just haven't been in court. Let's see. I'll mod for free if you move to Florida. Lois, you know, I loved my trip down in Florida. As brief as it was. The counter's working. Back up to 107. As brief as it was, but I like water a lot. I like getting in water. I like swimming. I'm not talking like skinny dipping stuff, but just like swimming in streams and wading and, you know, going fishing and getting up to your waist and out there fly fishing. Water in Florida is just a means to slow down the food for the alligators. And I'm the food. And I'm slow enough already. And between me being slow and the water, I have no hope. I would make a very fat gator. Ocean has plenty of space. Try buying oceanfront property sometime, though. It's rare to find some, and when you get it, it's marshland and not allowed to build on, or so rocky that, you know, it's terrible. You can't just go find your own private island anymore and plant a flag and call it yours. I mean, I realize that's what Columbus did, but those days have sailed. Unless I win Mr. Beast's private island contest, I'm probably not getting one. Need to be near the ocean. I love the ocean. Says Stephanie. I've got my flag right here. It's not like Canada where water is the norm. Yeah, Canada, you're looking for land. It's like, have you seen land nearby? You've got land of a billion lakes. I thought rocks are good. They are, real government name, but I want a variety. Like riverbed rocks washed down from the mountains of, you know, hundreds of miles of mountains where you've got variety. And, you know, there's some rocks have gold in it and some rocks have copper and some are igneous and some are sedimentary and everything. I want like the full gamut. All right, people are coming in. I think we're expecting the defendant shortly and the judge right after. You can live on a houseboat at ICW and not pay rent. Ooh, the Intercoastal Waterway. Eventually, the people that own the houseboat would want me to either pay or get off, I'm thinking. How do you manage not paying rent? I'm curious what you're trying to sell me there, Lois. It sounds tempting. Montana's great for rocks. I've loved rock hounding up in Montana. I've rock hounded it in Montana, Wyoming, Idaho, Utah, Colorado, Nevada. I don't think I've been to Arizona for that. At least not significantly. I think that's all. And I've looked for them here in North Carolina. I haven't found any yet. 7 years in. Judge is here. We have to stop talking about rocks.
Okay, let's go back on the record. State's attorney's present, defendant and defense counsel are present. At this time, I'm not going to change my previous ruling with regard to the request for a directed verdict. We are where we are with regard to that. With regard to the jury instructions and the charge that you guys, the draft that has been given to you, containing only the single paragraph 1 of the indictment. Are there any At this time, any objections, corrections, or requested additions from the state,
No.
from the defense?
As long as my error is preserved with regard to my motion for corrected verdict, I don't have a problem.
Okay, thank you, it is. How long would either of you request for closing?
10 minutes. 15, maybe 20.
Okay, I'll let you know if you get
I'm not
past
gonna-
that. You can bring the jury in.
Judge, I did have one.
Hold on.
Typo I found.
Well, that's the correction that I just asked for.
But if you look on page 5, under in Jefferson County Honor about March 27th, 2022, that Kalon Johnson.
Thank you, that's what I'm asking there. And did I spell that right? Kalon Johnson spelled correctly, correct, right?
I think so.
Looks right when you get it.
Okay, so I just changed the to that on page 5. Anything else?
That's all I saw.
All right, bring the jury. Gigi, we are incredibly lucky. I'm blessed. I love it. The idea that I can, as long as I have high-speed internet, I can do my job wherever I am. It's awesome. It is wonderful. It's incredibly freeing. So, as long as we have rocks. I think the judge just left to print.
I got it. Good enough. Thank you. All right, now you can bring the jury in.
Need to rest.
Okay. Yeah.
Defense is going to rest. We're going right to closings.
Take a nap. No, I would like to.
Jury's walking in. They're almost done.
All right, let the record reflect the jury is seated. Thank you for your patience. State's attorneys present, defendant and defense counsel are present. Mr. Radford, are you ready to proceed?
Yes, Your Honor, the defense rests.
Okay, thank you, Mr. Radford. So ladies and gentlemen, what that means is that at this time you have all of the evidence that'll be presented. The next thing is for me to read the court's charge, and then you'll hear closing argument by counsel. I'm going to read the charge to you now. Cause number 24, DCCR 0348. The State of Texas versus Joseph Charles Freeman. Jury instructions. Members of the jury. The defendant, Joseph Charles Freeman, stands charged by indictment with the offense of murder. Bless you. The defendant has pleaded not guilty, and you have heard all of the evidence. The parties will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether or not the state has proved the defendant guilty. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable in this case. General principles. The indictment is not evidence of guilt. The indictment is a document required to bring the case before you. Do not consider the fact that the defendant has been arrested, confined, or indicted or otherwise charged. Do not draw any inference of guilt from any of these circumstances. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless the state proves each element of the offense beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient for you to return a verdict of not guilty. You may find the defendant guilty only after a careful and impartial consideration of all of the evidence and only if the state has proved the defendant's guilt beyond a reasonable doubt. The state has the burden to prove every element of the offense beyond a reasonable doubt. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If it does not, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that's in dispute. The law requires that you render a verdict of either guilty or not guilty. The verdict of not guilty simply means that the state has not proved the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand, or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Rules that control deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to pick your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1. You must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2. You must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. 3, you must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the state has proved the defendant guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use the form attached to these instructions. The foreperson should sign the line that corresponds to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Law specific to this case. The state accuses the defendant of having committed the offense of murder. Specifically, the accusation is that the defendant is guilty of murder by either intentionally and knowingly, intentionally or knowingly causing the death of Richard Shiloh by shooting Richard Shiloh with a firearm. Primary actor liability. First, the state contends that the defendant, by his own conduct as a primary actor, committed murder. Party liability. Second, the state contends that Kaylin Johnson committed murder, and the defendant is criminally responsible for this offense as a party because the defendant solicited, encouraged, directed, aided, or attempted to aid Kaylin Johnson in committing it. Relevant statutes. Liability as a primary actor. A person commits the offense of murder if the person intentionally or knowingly causes the death of an individual. The defendant acts intentionally as required by this offense if it is his conscious objective or desire to cause the result of death. A defendant acts knowingly as required by this offense if he is aware that his conduct is reasonably certain to cause the result of death. Responsibility for conduct of another as a party. A person who does not by his own conduct commit an offense may nonetheless be criminally responsible for the conduct of another person. A person is criminally responsible for an offense committed by the conduct of another if, acting with intent to promote or assist the commission of the offense, he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. A defendant acts with intent to promote or assist in the commission of an offense when it is his conscious objective or desire to promote or assist in the commission of the offense. A defendant's mere presence alone will not make him responsible for an offense. A defendant's mere knowledge of a crime or failure to disclose a crime is not sufficient. A defendant is guilty of an offense committed by another under the law set out here, even if that other person has been acquitted, has not been prosecuted or convicted, has been convicted of a different offense or of a different type or class of offense, or is immune from prosecution. Definitions. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Application of law to facts. You must determine whether the state has proved beyond a reasonable doubt that the defendant is guilty of murder, either as the primary actor or as a party. Liability as a primary actor. You must determine whether the state has proved the defendant committed the crime by his own conduct. To prove this, the state must prove beyond a reasonable doubt 2 elements. The elements are that 1, in Jefferson County, Texas, on or about March 27, 2022, the defendant caused the death of an individual, Richard Shiloh, by shooting Richard Shiloh with a firearm. 2, the defendant did this intentionally or knowingly. If you all agree the state has proved beyond a reasonable doubt both elements 1 and 2 listed above, you must find the defendant guilty. Liability as party. If any of you fail to agree the state has proved beyond a reasonable doubt both elements 1 and 2 listed above, You must next decide whether the state has proved beyond a reasonable doubt that the defendant is guilty because he is criminally responsible for the commission of a crime committed by the conduct of another person. This is the case if the state has proved beyond a reasonable doubt 4 elements. The elements are that 1, in Jefferson County, Texas, on or about March 27, 2022, that Kalen Johnson caused the death of an individual, Richard Shiloh, by shooting Richard Shiloh with a firearm. 2, Kalen Johnson did this intentionally or knowingly. 3, the defendant solicited, encouraged, directed, aided, or attempted to aid Kalen Johnson to commit the offense of murder. And 4, the defendant acted with the intent to promote or assist the commission of the offense of murder by Kalen Johnson. If all of you who did not find the defendant guilty as the primary actor agree that the state has proved beyond a reasonable doubt each of the 4 elements listed above, you must find the defendant guilty. If you all agree the state has failed to prove beyond a reasonable doubt either element 1 or 2 listed above establishing the defendant's guilt as the primary actor, and has failed to prove beyond a reasonable doubt 1 or more of elements 1 through 4 listed above establishing the defendant's guilt as a party, then you must find the defendant not guilty. You need not be unanimous about the theory underlying your guilty or not guilty verdict. If you all agree the defendant is guilty either as the primary actor because the state has proved elements 1 and 2 of primary actor liability beyond a reasonable doubt, or as a party because the state has proved elements 1 through 4 of party liability beyond a reasonable doubt, then you must find the defendant guilty. If you all agree the state has failed to prove beyond a reasonable doubt either element 1 or 2 of primary actor liability, and has failed to prove beyond a reasonable doubt 1 or more of elements 1 through 4 of party liability, you must find the defendant not guilty. Aren't you glad you're going to have a copy of that? Yes. Then that has my signature line, and then the last page is the verdict sheet. It reads at the top, verdict, not guilty. We, the jury, find the defendant, Joseph Charles Freeman, not guilty. And there's a line for the signature and then the printed name of the foreperson. And then below that, verdict, guilty. We, the jury, find the defendant, Joseph Charles Freeman, guilty of murder as charged in the indictment. And again, there's a line for the signature and then the printed name of the foreperson. Mr. Coleman, you have the right to open and close closing arguments.
Thank you, Your Honor. The state at this time waives its right to open. However, we will reserve our right to close.
Thank you, Mr. Coleman. Mr. Bradford, you may proceed.
Whoa.
Remember, this has been a very short trial. Remember Monday we talked about the state having to prove all of these elements beyond a reasonable doubt. And they do that because if you're going to put a young man in prison for a long, long time, you better have really good evidence. I'm going to ask you a question right now, and you can't answer, but just answer to yourself. Who killed Richard Shiloh? Who did the state prove killed Richard Shiloh? Who? Now, it's in the charge, it says Kalen Johnson. And we know from Detective Tamayo that Detective Tamayo pulled over or arrested Kalen Johnson and some other guys for stealing the car. And that they had some guns in the car. Where are the ballistics? Why did not they tie these guns to the death of Richard Shiloh? Who is Kalen Johnson? We didn't hear anything about Kalen Johnson killing Richard Shiloh. Why? Because they have to prove that first. They have to prove that Kalen Johnson committed murder if they're going to prove that Mr. Freeman helped him do it, aided and abetted. And they haven't done that. What evidence have they brought you? There are 3 verdicts I submit to you. There's guilty, there's not guilty, and they didn't prove it. Because that's their job, is to prove it beyond a reasonable doubt. And they didn't prove who killed Richard Shiloh. We don't know what happened. We have a video, but we don't know what happened in that car. We don't know if Richard Shiloh pulled his gun out. We have evidence that Joseph Freeman was shot. And then we have evidence that somebody, they haven't identified that other person, shot Richard Child. And then you have to ask this question. Assume that Kalen Johnson, again, who we don't know, intentionally or knowingly caused the death. Did Joseph Freeman give him that boost up to the window that Mr. Coleman said? Did he do that? Because there's something in the charge that I want you to read. It's on page, where is it? It's on page 4, very bottom. A defendant's mere presence alone will not make him responsible for an offense. A defendant's mere knowledge of a crime or failure to disclose a crime is not sufficient. A defendant's mere presence alone will not make him responsible for a crime. What evidence have they brought you that this young man helped whoever it was that killed Richard Shiloh? Nothing. Nothing. There's a video of some kind of altercation that happened in about 10 or 15 seconds. And I would submit to you that that's not enough evidence to prove a murder charge. That's not enough evidence to prove that this man intentionally or knowingly killed Richard Shiloh, or he helped this unknown Kalen Johnson kill Richard Shiloh. Because you've got to have better evidence than this to put somebody in prison for a long, long time. And I would submit to you that it's just not there. They haven't met their burden of proof. There's so many holes in this bucket that the water's just pouring out of it. And this man is not guilty.
Thank you, Mr. Radford.
Oh,
Mr. Coleman?
Thank you, Your Honor. Mayor, Peace Court, Mr. Radford, ladies and gentlemen of the jury. I want to begin the way I began during our jury selection by thanking you all for being here. Thank you for your time and your attention on behalf of the District Attorney's Office, on behalf of our community, and most importantly, on behalf of the victim in this case. The victim in this case, Richard Shiloh, you heard the testimony. He was no angel. He was no saint. It was unfortunate that he sold drugs, but selling drugs is not a death sentence. He should not have died as a result of a poor decision that he made to sell drugs. Like we talked about during jury selection, I want justice for Richard Shiloh. A couple of things I want to point out in the jury charge, and you will have a copy. You can take it back with you, and you can read it for yourself. It says that you are permitted to draw reasonable inferences from the evidence. That's what I'm asking you to do. It goes on to say that you can use your common experience to do so, and your common sense. Most important, your common sense. I mean, if you think about what we talked about in jury selection, that jigsaw puzzle and wanting to have all the puzzle pieces, but if you've got enough of the pieces there, using your common sense based on the evidence, then that's enough, ladies and gentlemen. I mean, think about it. Defendants who are planning or conspiring to rob
Objection, Your Honor. He's arguing facts, not into evidence. There's no evidence of robbery.
I think it can be a fair judge, but I'll rephrase it.
Thank you.
Defendants who are planning to murder someone in order to take their property.
There's no evidence.
Objection, Your Honor. Again, that's just.
It's closing argument. The jury will read the charge.
To take their drugs or their firearm, they aren't going to have a signed contract that I can bring in here and show you. Look, they all signed a contract. They won't have a notarized agreement. Hey, by the way, this is what they plan. So by necessarily, you need to use your common sense and infer from the evidence. And what can you infer from the evidence? Well, one is you saw the video of where that driver, the getaway driver, parked. Why on earth would he go through the effort to make sure that he's parked out of the line of sight? You know, if this is just a legitimate drug deal, then, or not, is there a such thing as a legitimate drug deal? If this was just a drug deal, then why park out of the line of sight so that Richard Shiloh couldn't see the car? In fact, you'll note that when everything goes down and this defendant and Kaylin Johnson starts running, they don't run back around through the apartment complex like they came. They take the most direct route to that vehicle. They run straight to that vehicle. So that's the first thing I'd ask you to use your common sense on. The second thing is, my goodness, if he didn't know that Kaylin Johnson was going to shoot this guy, and it all goes down, shots ring out, and this guy's lying there bleeding, why on earth take his gun and run away with it? Who does that? Who does that kind of thing if they're shocked? Oh my God, what just happened? No, someone with a criminal intent, someone who was intended to take something or something or things, takes that firearm under those circumstances. They run to that vehicle and jump in as if it were the plane. Why? Because it was the plane. So I'm asking you to use your common sense, ladies and gentlemen. Mr. Radford, who, by the way, is a formidable advocate, he made the point that there is no evidence that Kaylin Johnson was the person that's shooting him. I submit to you, who shot the victim, I submit to you there is evidence. The defendant's own words from that sworn testimony or that transcript that was entered into evidence, he says in the transcript, he was there with Kaylin. Yeah, it's in. It's good. You can read it. It's in evidence. But I also submit to you that's a rabbit trail because regardless, he was there and he aided that other individual. The other individual, Kaylin Johnson, that he identified in his transcript, his aid promoted and assisted, like we talked about during jury selection. Don't fault me for using an example about giving somebody a boost up to a second story window. It just was an example. There are other ways you can aid, assist, or promote somebody.
This guy's
One
all
of the
over the
ways
place.
is, hey, when you do this, I'll do that. In other words, you point the gun, shoot the gun, and I'll grab these things. That's another way to aid, promote, or assist. Don't hold me or lock me into my example that I just used during jury selection to make a point. And speaking of shooting, I found it interesting. I didn't snap to it until actually while Dr. Kanan was on the stand. It was a close contact wound in the left side of that victim's Richard Shiloh's body. Think about it. If you're reaching in and you're going to shoot after some argument starts, that firearm, why on earth would it be pressed against that victim like that? I submit to you, you can use your common sense to infer, no, when that door opened, Kaylin Johnson put that gun against him, and he being shot, Richard being shot, turned so that his left side was exposed in order to kind of maybe shield himself. After being shot, then shot again in the back. I mean, again, these are all things that you can infer. It was only a matter of seconds. You can see it on the video. You can watch the video if you want. It wasn't even time enough for there to be an argument. They walk up to that vehicle, and in a matter of seconds, they're shooting and they're running off. Think about this. You heard from Alizé Ballard. She was on the phone with Richard at the time. I mean, excuse my language, a badass would Richard Shiloh have to be to argue? He's on the phone, he's brandishing his firearm, and then he's arguing with these guys. That was not the plan. Richard Shiloh was on the phone with his girlfriend because he thought this was just going to be a drug deal, and then boom, 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 he got it. And that's how that happened. These are all things that you can infer from the evidence in this case. And I'm asking you to do just that. Use your common sense and don't get distracted or fooled. A couple other things and I'll wrap up.
Don't be
there's language in
distracted
here
with
about whether or
food.
not this defendant was the primary actor or the one that shot Richard Shiloh versus being a party, promoting, assisting. I would submit to you that the evidence clearly points to his actions being as a party to this offense. I would submit to you that you don't spend any time on whether or not it was Joseph Freeman who pulled the trigger, who shot Richard Shiloh. Don't spend any time on that. I submit to you, just focus on the party language. did he promote, assist in the commission of this offense? To do otherwise, to let this defendant skate on this offense would not be justice for Richard Shallow. And I'm asking that, based on the evidence in this case and your common sense, that, ladies and gentlemen, oh, one last thing before I forget. I get it, he wasn't the shooter, but that does not absolve him from guilt or responsibility. That's something that, in the event you find him guilty, you can take into consideration during punishment, okay? But nevertheless, I'm asking you to find him guilty as a party to the murder of Richard Shallow. Not because I say so, or because Sergeant Tamayo says so, or Detective Thompson says so. I say find him guilty because that's what he is. He's guilty for assisting and promoting in the murder of Richard Shallow. Thank you, ladies and gentlemen.
Thank you, Mr. Coleman. So, ladies and gentlemen, I'm going to give the three instructions to the bailiff, and she will get you situated in the jury deliberation room. You can select your foreperson and begin your deliberations. And so for the alternate, if you'll just wait right there, we'll give you your instructions. For the rest of you can go with the bailiff, and we'll be in recess until you reach a verdict.
There they go. These are the deliberators. Starting the timer now. And we are in recess. I've heard some bad closings before. But this guy, like, woke up after his afternoon lunch not knowing that he was going to do a closing, then seemed surprised by the fact, waived his initial opening, so he just wanted the big finish, and then this is all he delivered. And it was everywhere. It was just... That was nuts. Was it nerves or unprepared? Or lack of evidence? Does he just have nothing to talk about? Man. I was hoping that what we would hear there, this wasn't bad, it was mind-blowing. I was hoping that what we would hear there is some sort of summation of the facts, something that would put all the pieces in order, at least maybe, at a bare minimum, list how your evidence met the elements of the charge. But defense made sense. They stood up there and it made sense what they were saying. You might not agree with it, but it was reasonable, it was rationable, it was followable. And then the prosecutor got up there and gave, the equivalent of my 4th grade class president speech, which I didn't win. Probably because the root beer drinking fountain promise had been overplayed at the time. That's what I'm going to blame. I did lose to a young man who showed up wearing Superman underwear on the outside of his pants. But that's neither here nor there. That was terrible. That was terrible. Honestly, the kid I lost to was wearing his underwear on the outside, and it was Superman. Better than no pants. Yep, it was.
Scratch all that. Oh, that was terrible. I apologize.
Not to mention the facts. Tells them disregard. Don't pay any attention to the fact that he's not the one that did it. He's a party. We know that because he got shot. He wouldn't have got shot unless he was in on it, right? What? He might have just shown up to buy weed. And his buddy did it on his own. I don't know. Maybe it would have helped to see the video a little bit, but I'm hoping the video is really clear for the jury and they can figure this one out and do the right thing here. But what I saw. Are we in verdict watch on 2 trials? No, Brady B missed Judge Boyd's. That one came back already. It was yesterday-ish or the day before. Monday-ish, I think. We'll spoil it for you right there. Guilty on both counts. Let's do some court hopping, shall we, while we wait for a verdict. We're going to keep the audio on this court. We'll keep that locked on. Won't touch that button, and we're going to go over here and see what other court cases are happening in the world of true crime. There's a response about Sarah Boone that I might read as well. Who's this? Hang on. This is Judge McBurney's doing something. What's he up to?
Businesses in trust, these signing bonuses up to about $50,000 in that. And she's told me she has a bank account with over $200,000 in it. She made a lot of money during COVID as a travel nurse, and $250,000 was in some account at some point in time. And she's told me of these large amounts of money.
It's a divorce. He only does divorces now. McBurney, got to do something different. Although those might be interesting sometimes. We tend to not be there. He's moving on to divorce court. Let's see. I'm looking for... We've got some felony hearings with Judge Brantley Clark.
Yes.
Okay. All right. Well, I'm going to find that I've already found he willfully violated the terms and conditions of his probation. His probation was revoked. He's adjudicated guilty of possession of cocaine, possession of a controlled substance. He is sentenced to 24 months in the Florida Department of Correction on each one, run concurrent with each other. He's given credit for how much was that? 64 days on each count.
Half a year.
All fines and costs previously imposed are reduced to a civil judgment. There's an additional $100 imposed. What does that cost you, please? Cost sheet on the VOP, $100. That's also reduced to a civil judgment. I'm trying to have court. Mr. Jones, you have 30 days to file a notice of appeal if you wish to appeal your judgment sentence. If you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir. You need to step over and be fingerprinted. And on the new charges, we want to set in for maybe the 20th.
I'll take care of it, Your Honor.
Okay.
He can be transported to DOC.
All right, he'll go ahead and be transported to DOC. We'll go ahead and set just a tracking date for August 20th.
Thank you, Your Honor.
Yes, sir. Thank you. Hold on just a second. Let me talk to y'all just for a second.
On the record or off, Judge? We like the off record. Oh, off the record and outside of our hearing as well. That's no bueno. Let's see. See who else. Judge Simpson was working today. Let's go back and see how his morning was. Oh, it looks good already. This is great. Hang on one second. Okay, there we go.
Most kids will figure it out. I think this is too.
No, this is totally true. I agree with you.
Granted.
I don't know how we're up for this film.
I know.
I'm like worried about tonight.
All right.
What does this shirt say?
14A District Court, County of Washington, State of Michigan, down in Session. Although we haven't been court trial hearing, the Honorable J. Session Simpson preside.
You may be seated. Court does call the case of the People versus Sapovan Cartwright.
Joe Simon on behalf of Sapovan.
What does this shirt say?
Sapovan?
Something yes. Bottom?
And please state your name.
I'm Pratap Sapovan. Brent.
And Your Honor, we're here for sentencing. Probation said that they would provide the court with a copy of my client's assessment and program completions, which he's done. The recommendation reflects that he did his VIP and early intervention, etc. We ask the court to adopt the recommendation. He can pay those fines and costs today.
All right. Sir, is there anything you want to say before I impose sentence?
No, Your Honor.
Sentence of the court, going to order $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs. You can pay all of that today?
Yes, sir.
All right, pay that today out at the counter. I'll order 93 days in jail. Credit 1, the balance is suspended. Okay. Thank you.
You're welcome.
Wait for me outside. Your Honor, may I approach the bench on another matter? I know. Thank you.
Trying to get the timer on the screen. Give me just a second. We'll have that set up for you. We're still sub 10 minutes on the timer for jury deliberation. Drop that down and bring this over. There we go. There's our timer. What about the guy in the car? What his shirt says? Does anyone read that? Bikini bottom SpongeBob? Oh, nice. It's a SpongeBob shirt. I think that'll go great with Judge Simpson's yellow shirt. SpongeBob in court. Who would have thunk?
Oh, it's fine. Line up somebody.
What was that? Was that from Judge West's court? I don't have audio coming from anywhere else. I got my iPads configured. Now I just have to figure out how to configure the configuration and get them issued so I don't have them sitting around here anymore. Got to figure out what dude in the car is here for. Hatchman wearing a SpongeBob shirt in court. I'm not sure if that's like a bold move. Is it a slap in the face of the court, or is it just, this is what was clean, Judge? Thought it'd be better to wear a clean shirt than a dirty one. We did a poll, Shelley Small, but I screwed it up and I just haven't had the heart to do it again. I put the question as one of the answers. I killed it after 35 votes. Do mods have the ability to do polls? Okay, I'm going to fast forward just a little bit because we can, but I sort of want to see what Bikini Bottom here does and how animated the judge is getting. I wonder if it's getting mad for the rest of the day, and that might be an indicator of what's coming. He's still listening. It takes a long time to finish. Okay. He's smiling at the end. That's a good indicator for Mr. Bikini Bottom. Okay, bring us back, Judge. Lois, you don't have the anything?
There it is. Court does call the case, People versus Carlos Hicks.
Good morning, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Hicks, who should be appearing via Zoom.
How you doing, Carlos Hicks?
All right. Do you have a camera, sir?
Oh, yes, I do.
Can we see
I'm
it?
currently just getting off of work. So here we go.
Okay.
I'm currently on my way home. I'm just getting off of work, sir.
All right. Very
Just
good.
hold still.
Go ahead.
Yes, Your Honor, I did have the time to review the PSIR with my client. We have no additional factual corrections, deletions, and insertions, so we would ask the court adopt the recommendation of probation.
Great. Mr. Hicks, is there anything you want to say before I impose sentence?
No, sir.
All right. Sentence of the court, place you on probation for a period of 12 months. You're to pay $555 fines and costs, $360 probation oversight fees. When can you pay that?
Currently, I'm trying to, I could have that paid month to month before I get off of probation. I have that 500 fully paid because.
All right. Your payment plan is arranged by probation.
Okay. I just do a payment plan with my probation officer.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Beyond Barriers or comparable program. You're to complete 25 hours of community service with proof to probation. You're to begin and maintain employment with verification to probation. I'll order 365 days in jail. Credit 51. The balance is suspended. All right. Thank you.
Okay. You're welcome.
Thank you, Your Honor.
Court calls case People versus Amanda James.
Good morning, this is Paul on behalf of Mrs. Banks. I don't see Miss James in the courtroom. I did speak with her.
Warrant.
Bench warrant will issue. Oh, go ahead, Ms. Blair.
I was going to ask the court to issue a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. I'll give a 10% privilege on that.
Josh has a poll up.
That warrant will
Thank you,
issue
Josh.
immediately. Court calls case People versus Shaletta Keith.
Good morning, this is Public Defender Lauren Kearney on behalf of Miss Keith.
I don't see her either.
Not sure.
Yep.
I spoke with Miss Keith as well. She's planning on being here.
Just gets busy.
Sentence. I don't have an explanation for her failure to appear.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. 10% privilege on that. That will issue immediately.
We're split 50-50 on the poll right now. Did the state prove their case? Make sure you get
Court
your voice
calls
heard.
case People versus Neoplasters.
It matters.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Plasters, who I believe is here. Mr. Plasters, state your name, please.
Neil Plasters.
Okay, thank goodness, huh? All right.
He's not Hatchman.
Your Honor, we did sentence report. We ask that you adopt the recommendation.
Right. Sir, is there anything you want to say before I impose sentence?
Just that I was incarcerated for 6 months prior to coming here. I just got a job a month ago, and I know they wanted $800 to be paid. I get paid every Friday. I currently can pay around $400 right now on this $800 that I owe or whatever they want for restitution. But other than that,
You said you have $400 on that? I didn't understand that part.
Well, some are right around there. I have to check my bank, but
okay. All right. Sentence of the court, $125 statutory fee, $800.08 restitution to Aaron Brown payable through the court. So you can get 400. Can you get 400 to the court by Friday?
Yes, I can definitely do that by Friday.
All right. So 400 by Friday, the 24th.
Yes.
By July 24th. And then how would you pay the balance?
I would start, I guess, a weekly. I could do weekly payments. I get paid every week.
All right. So how much can you pay each week?
Well, I have court fines in Livingston County too. I could probably do $50 a week.
Okay, that's fine. So then $50 per week. I'll indicate that's to begin August 7th.
Okay.
Okay? And
All
then
right,
I'll order 90 days in jail, credit 90, sir. All right. Thank you, sir.
Yes, thank you.
Mr. Plasters, please, that has to be paid in cash.
Yes. Can you, where do I have to pay it at?
You can pay it at the 14A1 court.
At the 14A1 court?
Yeah, the one by the sheriff's department from here.
Okay, and Hogback?
Right. Yeah, Hogback.
Okay, thank you. I'll have that paid on Friday.
You know where that is, right?
Yes, yes, I do.
Okay. All right. All right.
He knows
You
where the
take care of
jail is 'cause
yourself.
he's been there.
All right, thank you.
Court calls the case. People versus Ralph Chappell.
Yeah, doing the right thing, paying his fees, doing his time.
Who?
Yeah. Okay, go ahead.
On a prosecutor deferred sentence. He has completed all terms ordered by the court, and his appearance has been waived. Probation recommends that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation with the court.
You know, the way she was acting this morning, I just want to say no. I just and see what she does. I don't know. All right. Hearing no objection, so ordered. Court calls case of the people versus Nathaniel. Is it Laurent?
Yes. Good morning, Your Honor.
Good morning. What is he here for?
Costs. He's already received instructions.
All right. Sir, you are asking for additional time on your payments?
Yes, I am.
All right. Okay, I see what you're sending me. Are you working at this point?
Yes, I am. I'm currently at work right now.
Okay. So when you sent this in to me, you had said that you were going to pay $70 on July 7th. Did you get that paid?
Yep. Yes, I did.
Okay. And then you want a payment plan of $50 per month, right?
Yeah. Correct.
What do I have him owing? I got
10:30.
10:30. All right. Given everything that's in there, I'll allow it. So I'll indicate defendant to pay $50 per month. When are you going to make your first payment? Would it be August 7th?
I get paid 2 times a month, so probably would it be okay to do that like towards the end of the month?
Okay, I get you.
Yeah.
All right. So what I'll do is $50 per month beginning August 28th.
Okay.
2026. All right. Thank you, sir.
Thank you. Take care.
Bailiff's
You do the
doing a
same.
lot of swiping left. Not sure what he's up to.
Court calls the cases, I think. Of the people versus Eric LZ Williams.
Cases, plural.
Oh.
Eric LZ Williams.
All right.
Are we here for show cause here?
Yes. He owes on the case ending in 1229. We currently have a balance due of 1187. And then on the other matter, I have a balance of 549.
Your Honor, I believe that Mr. Elsie Williams indicated that he was going to make a payment of $200. Were you able to do that, sir?
Yes, I paid $200 this morning on the 1187 case.
On which one?
The 1187. I put 200 on it this morning.
That was the Ipsy case, he said. And I gave.
On the 1229, he put 200 on that one.
Yes.
Okay.
And Mr. Elton says he's back to work. He says $50, he paid $50 a week going forward.
A week?
Yes.
Is that right, sir?
Yes, Your Honor.
All right. So when can you begin paying that?
Next week.
So the 31st?
Yes.
All right. Defendant to pay $50 per week, beginning July 31st, 2026. Well, yeah, I'm gonna do that. So so I want you to pay that on the case that ends in 0378.
Okay. That's for the $500 in
Right. So we can try to get that one out of the way as quickly as possible.
Okay, no problem, Your Honor.
And then on the other case, defendant to pay $50 per week, beginning, well, it's going to be about 10 weeks out or so. 2, 4, 5, 6, 7, 8. Beginning October 9th. So get that other one paid off, and then you can begin paying on this other one. Okay?
Okay. Yes, Your Honor.
All right. Thank you, sir.
Thank you.
Court calls case People versus Lamar Hampton.
Good morning. Assistant Public Defender Lauren Kearney on behalf of Mr. Hampton. Not checked in. Well, Mr. Hampton was in the lab hearing. Well, I don't know if you remember it. It was just a few minutes after the hearing in my office. And he submitted the warrant recall on his behalf. I will say, he did make a payment. He's made a couple of payments in the last couple of months. I calculated everything. He has paid $300 since he was originally sentenced. The original sentence was $250, but because sometimes work they show cause hearings, he has gotten the warrant fees, late fees, etc. So he is making an effort to pay it off. Like I said, the original sentence was $250. He's paid $300. There is also an entry from April 29th that the court would consider waiving the balance to be paid $185, which he did do. So on behalf of Mr. Hampton, I know it's not here, but I have.
I already wrote it. No, but I'll let you talk if you want. I mean, all right. Although the defendant failed to appear, I'm going to waive the remaining payments. Court calls the case People versus Keith Malone.
Good morning. Public Defender Laura Perry on behalf of Mr. Malone. Now, I attempted to get in touch with Mr. Malone.
Oh, right there. He's been here all day.
She was about
all
to
day.
give him a bench
How
warrant.
come you didn't know?
It's hard.
Yeah, the number we have for Mr. Malone is disconnected, so I wasn't able to get in touch with him.
Okay.
If it was about $800, I would ask you to tell the court what you can pay moving forward.
I recently was incarcerated. I'm seeking jobs, so I don't have anything right this minute.
Working right now?
No.
How long were you in?
I did 53 days in Wayne County, and then they transferred me over here on this case, and this case is 10 years old, and I was released from it, and I don't understand why. Like, I still had a warrant and stuff, so I didn't even know anything about it until I got put over. So this case like 10 years old.
What's my September date? Give you time to try to get yourself straight. So what I'm going to do is I'm going to adjourn this to September 9th. All right, 2026, 9 a.m. That way you can get yourself employed and you be able to come back and tell me what you can do.
Okay.
Fair enough?
Yes, sir.
All right. Thank you.
Thank you. I can give you a new number.
Yeah, this.
Court does call the case. People versus Amari McGee.
Okay.
Assistant Public Works Buckovich on behalf of Ms. McGee.
Oh.
Oh, there she is. Hello, Ms. McGee. All right.
Your Honor, today is the time and date for show cause. I was actually unable to speak to Ms. McGee for today's hearing, so I would ask her to explain when she'd be able to pay off the rest of the costs and fines.
All right. I have 825 due. So when do you think you can get that paid?
I'm on break from work for summer break, but I go back in. Starting date is August 31st. And I get paid bi-weekly, so I got my schedule for the first 2 weeks. So I'm thinking like maybe at the end of September I want to pay by the end of September. I want to pay like half of it, half of the remaining, and then my next check, the other remaining.
All right. So here's what I'll do. Defendant to pay $400 by September 30th. Okay. Is that what you were saying? What were you?
Yeah, but can I get a little, can we do payments, payment plan?
Okay, I thought you were gonna just pay it all.
I do. I that's what I plan to do, but I don't want, if I'm not able to, because I got other responsibilities, I don't want it to be another, situation where I gotta come in.
Wow. That was insulting to me.
I'm sorry.
No, she first of all told me that she's got things more important than me. And then I don't want to come see you, Judge. Wow. It's okay. I'm hurt. All right. So you get paid every 2 weeks, right?
Mm-hmm.
Okay. So what can you pay every 2 weeks? Let's start with that. How much do you think you pay?
Let's say $100.
Okay. So every 2 weeks you can pay $100.
Mm-hmm.
That's good.
Okay. You're starting work what date? You said the beginning of September?
Yeah, well, August 31st.
Got it. Okay. And so here's what I'm going to do. Defendant to pay $100 beginning September 25th. Got that?
Okay.
So here's what I was trying to do so that you know. Because you probably not working and not having a check, you probably promised a lot.
Yeah, that's what I was thinking. But, when I get my check, I'm going to try to pay more than that $100.
No, I got you.
I
okay. Listen, I'm trying to help you out. Okay. Because I realize if you haven't been working, you got to try to get things sorted and all kinds of stuff, and stuff comes up. So I'm not looking for you to pay anything out of that first check. That's why I'm going to start it the last Friday in September.
Okay.
Okay. And then you can then go every 2 weeks and get that paid. All right.
Okay. Thank you, Judge.
Okay.
All right, have a good day.
All right. Thank you.
Thank you.
You do the same.
Thank you, Your Honor.
That's it. You know what? I've been real nice this morning. That has to end. It doesn't make me feel good. I get uneasy when that. You know what? It's hurtful. Just letting you know. I'm blaming everything on you. That's what happens. You come in here and you. Wow, right? What kind of an attitude? Court stands in recess.
There we go. Court stands in recess. He's out. All right, we're still waiting. We are 33 minutes into deliberation. It seems like it's been an hour, but it hasn't. Has not. Let's see if any other courts are working today. Judge West is on hold. Judge Wiggins. What do you think about that? Hello, sir. How you doing? Up in Michigan. Yes, please vote in Josh's poll. He'd appreciate that.
Court next calls the people of the state of Michigan versus Justin Kirk Keshik. It's case number 262232FY. Appearances counsel.
Michael Corcoran on behalf of the defendant, Your Honor, who's here.
All right, and it looks like we're here for a few things. We have a sentencing and a show cause. We had set the matter for a substance use assessment and a pre-sentence investigation report that was based on a plea taken to use of methamphetamine and operating while intoxicated back on July 8th. And then the court signed a show cause on July 16th for a positive test of THC on July 14th, failed to appear for a drug test as ordered on July 14th, failed to report the week of July 6th, and failed to make a payment plan with Community Corrections, owes $395. So let's deal with the show cause first. Mr. Keshik, you do have the right to have a contested hearing in this regard, in which the prosecutor would have to prove to the court that you did in fact violate the terms of your bond, or you could plead guilty to those violations.
He's got
Also,
a Sean
did we deal
Connery
with the
beard.
show cause from?
We did, Your Honor.
Well, I've got another one.
There may be
On
one
July
more that
10th that shows that he tested positive for THC on July 4th.
Your Honor, I was going to ask the court, this is partly, I guess, my mix-up, because on Monday of this week, I realized that my client had not filled out the packet and with probation. I had already provided counsel with a copy of the substance use assessment from Preston Green, but realized that didn't all get done. And the day of the plea was late. I think we left here at 5. I had to run and didn't have a conversation with Justin. And I guess I figured with his prior past, he would have realized what he needed to do, but he didn't realize that he had to do all of that. And that's my fault. So I had talked to counsel about requesting either just a 1 week or 2 week adjournment of these matters so that I could have him he's got his packet, meet with probation, then we could address the bond violations at the time of sentence. That'd be acceptable. I apologize to the court. That's not how I normally operate.
Is Carrie?
I appreciate Mr. Corcoran's explanation, but that explains why he didn't do the PSI packet maybe, but it doesn't explain bond violations. And I dismissed a whole bunch of bond violations already under plea. So it's quite concerning that he continues to violate bond. So I don't know.
Council, I received a report. This is the first time I'm seeing it. It looks like it came in today from Community Corrections on a program summary. Did both of you receive that?
I did.
I may have, but I might have been driving. I just.
Selena, can we get?
I don't think we have the substance use assessment for one who's referring.
Yeah, and we don't have the substance use assessment either.
I have a copy of it.
You gave him a copy of it? All right.
I have a copy of your substance use.
Carol Burnett had her own show, right? A variety show. And Barbara Streisand.
He has that.
They're both Broadway, right. I thought. Barbara Streisand was on like Funny Girl, Stars Born. Yeah. Who doesn't know them, Josh?
I also would inform the court that I believe my client paid that outstanding balance here today. Down to what, just $70 or? Okay.
All right.
He still owes $70.
Still owes 70. Ms. Matsky, you'd indicated in this report that you have not received a verification for any test that he has done. Is that still the case?
I received one verification of him testing from Harbor Hall as the first test that was ever taken. Since then, the only thing that I've received was results, which is days later, the verification, the day of the test. I have not received that.
I think I grew up listening to an LP of Barbara Streisand.
Do those show that the days he tested?
She's got that
Does it
Jenny
show the date
Rebecca
the sample was collected?
They do.
My name is Barbara. Yeah, I remember that one.
Court may recall that he actually did an extra test the week of the plea, which is now the week he's allegedly not failed to report. But
she got the Presidential Medal of Freedom Award.
Assessment, if you'd like to see it, John.
Well, since we don't have a PSI done, it doesn't really make sense for me to review that now. So I will set this over for sentencing, and we'll set it over for contested hearing. I'll let you make an argument as to why I don't lock Mr. Keshik up today. I know I said last time we were here, I didn't know why I wasn't doing it, and then the violations continue to rack up. So,
well, Your Honor, this was a drug case. He's not tested positive for serious drugs at all. He had one positive blow on his scram that was a result of the fact that he's a high-level painter. Otherwise, they've been all negative. He tells me, and
high-level
willing to admit to this, is that he took a couple of gummies from Wild Bill's because he has chronic back problems. He's not on any prescription drugs. He has years of high labor, and prior to that, he was an athlete in high school. And so he took a couple of these gummies, and turns out he tested positive. He's done. He understands that he can't do it unless the court allows him on probation, maybe with a card. He can use cannabis because that helps his pain. And the test bore that out. I think the petition says, yeah, that shows that he wasn't using THC before. So the test would be consistent with somebody who maybe took gummies a couple nights in a row. Otherwise, Judge, I know this to be a hardworking guy. He's out there 60 hours a week, and he has full-time custody of his young daughter. So I guess I'd ask the court to consider not jailing him today. And when we come back, we can address these bond violations. Otherwise, I think he does contest that he failed to report the confirmation, or whatever your county calls it. I can attest to the fact that Charlevoix right now and Emmett is really, we need another drug lab. They're only open during the day. If it's after hours, you're pretty much in a tough spot. And I think he had to drive over to Sheboygan once. Frankly, he has to go to Traverse City. It's really the only option. They can go after hours. That's 2 hours away. So it does pose, in terms of timing, a problem. But the tests themselves have all been negative, except for this recent blip with THC. So he's pardon me? Well, I know, he's aware, my client has a card, but that, he knows he's not supposed to use THC on bond. Okay, I've advised him of that. The
He
court's
does have a
advised.
card. He does have a card.
He does have a card.
Then he should be allowed to
We
use it.
provided a copy of that to, I believe, the compliance officer. So,
Ms. Matzke, is that accurate?
I do not have a medical card.
well, maybe it's is it Ms. Kamaski I mean, I saw an email directly from my client. The response was, please don't communicate directly with me, communicate through your lawyer, but I can attest that got sent
He
over.
sent that to our office, but
Okay.
I remember the email, I don't know what it said.
Okay, well, we're happy to provide the proof, but whoever's been filing the petitions is who we sent it to.
Ms. Carey, your take on it?
If he's got a card, I don't think you can revoke him for that.
Perplexed by I'm a painter, so I tested positive for alcohol. I don't know of any scientific proof for that, and I haven't seen any. And I read the pretrial program summary, and he's really walking a thin line with his compliance.
But he's walking the line.
He has these problems, and he's got so much responsibility. I would think that he would take this more seriously. When I read this report, he's not. So I'm going to leave it to the court, but thank you.
Well, if the defendant truly has a medical marijuana card, I don't believe that I can prohibit him from using it on bond. And I know I can't on probation. Why that hasn't been brought to my attention yet, I don't know. But it is clear to the court that the Community Corrections Office is clearly working harder than Mr. Keshik at trying to keep him into compliance. And then we also have the issue with not having a PSI done in time for sentencing. While that is not a violation through the community corrections, it is telling on the court. We are here on alleged bond violation number 6, and Ms. Carey is right. Several were dismissed earlier. So, Mr. Keshik, I'm going to remand you to the custody of the Wexford County Jail until we are here for sentencing or a contested hearing. Or you'll have to go with the bailiff.
He was not expecting that.
Does the court have an idea when the sentencing might occur?
I believe we probably have to set it out 2 weeks in time for the probation office to do a written report.
I've got my ex-girlfriend goes for her training next week, this Sunday. And
Mr. Keshik, these are all good reasons as to why you should have been doing what you should have been doing.
I understand you, Honor,
And so if a motion needs to be filed, Mr. Kokori knows how to do that. But as of right now, I'm remanding you to the custody of the Wexford County Jail.
Yeah. Well, he's going into custody. Didn't follow the rules. Hey. Didn't end well for him. But apparently, when the judge says that the probation office is working a lot harder than you are at keeping you in compliance, that's not a good thing. You need to be putting in some of that effort, some of that good effort. All right, let's see if we have any other judges to go to. Just approaching 47 minutes on the counter right now. 48 minutes. Wish Judge Middleton's audio was better. Has it gotten better at all? Have they fixed his courtroom? I hate that he's going to be leaving us and we can't hear a thing the last 6 months he's there. Let's see. Judge Stevens is doing something. Hope you brought a toothbrush. Yeah. Let's see what we got here. Looks like a trial. Looks like he's in trial right now. We've got evidence photos. I mean, it might be preliminary hearing, but we've got an audience full of victims. Defendant with lawyer. Prosecution with evidence all over the table. We might be in the middle of a trial, just stumbling on this one. What does the YouTube say? Just says personal meeting room. It's another murder trial. I just don't know much trivia, Jody. Watch Middleton every night. Audio is good, at least to me. I might have to check and see. It sounded like last time I saw him, he had a ton of echo because they moved into that old courthouse. Might be a little late jumping in on this one where we are. We've got crime scene photos on the table. And they are crime scene photos. Okay, where's Judge Middleton? Let's see if we can find him real quick. Judge Dad isn't live, is he? Nope, he was, but he's not. Judge Simpson's not. Parole is not. Out of Louisiana. Let's go to Royal Oaks.
On Main Street?
Parking.
Yes.
Okay.
Great cameras.
Did you pay for the parking?
No, I didn't. The reason why I called for a case is just because I had parked somewhere. I walked around the corner to see if I was in the right location, which I wasn't, and I got back in the car and I had already had a parking ticket. So that's why I called I was there just for, it was not very long.
Doesn't matter.
Well, you were parked and you didn't pay.
Yeah, right.
That's what it comes down to.
Yeah, I guess if I'm going to be there for 5 minutes, I guess I thought I would pay if I was in the right location, which I wasn't. And I was like turned around and anyways, but yeah, I guess I just thought it was kind of, maybe it just seemed kind of not an appropriate response to get a parking ticket for parking somewhere for 5 minutes, you know?
You didn't pay.
Ma'am, if it's expired for 1 minute, if it's expired, the fine is $20.
Okay.
Thank you.
Thanks.
Royal Oaks has to collect that revenue. A lot of judges would be lenient here, but Royal Oaks got a budget to meet. So he was calling here. Just 1 second.
Call from.
Screen name is Robin Zeinstein. What is your name?
To accept, press 1. To send a voice.
Hey, who is this?
Josh Hutchins.
Josh, what you doing?
Yeah. How much?
How did you not know Barbara Streisand?
You know, I'm young. You know, I don't know them people.
That sounds like an excuse that you might tell a traffic court judge about not paying a parking fine.
Yeah. Thing about that is I can't ever get pulled over because I'm in a wheelchair. So.
What, you're saying you can't speed? I bet you could.
Oh, I can speed. Yeah,
So
I just,
my friend's been pulled over on a bicycle for speeding.
I just called to call you and tell you what a wonderful mod you have. It at N as in red and amber.
They are good mods.
Yeah, and Lois.
Yep.
Yeah.
And Thomas.
I don't know about Greeners.
Greeners.
Oh, Thomas and Greeners.
And 6 volts.
Yeah.
Got cash out on there. We've got a few that lay low.
But, I said Lois right then.
Yeah. You know, Barbra Streisand won 2 Academy Awards, 9 Golden Globes, and 5 Emmys.
I did not know that.
You do now, though, and she did get the Presidential Medal of Freedom Award.
That's good.
So she's pretty much like Supergirl.
And who's the other lady we were talking about earlier?
The Burnett lady, Carol Burnett.
Yeah,
from
Burnett,
the Carol Burnett
yeah.
show. She had her own little comedy show.
Yeah, when was that?
30s, 1933-ish was when she was born, I think. Was it April? What was her birthday? April 16th? Somebody fact check me on that one. You're asking questions, I just don't know the answer. I think it's either April 16th or April 26th. 1933 was her birthday.
1933. Okay.
You don't remember that?
No, I was like still in my mother's home.
Well, she also won 7 Primetime Emmy Awards and 7 Golden Globe Awards. So, I mean, these aren't no-namer people we've got here. I don't know why I have these facts just available. It was April 26th. Okay, April 26th, 1933. See, I just know.
I was mainly just calling in because Cat was giving me a hard time.
Do you know how many times Carol Burnett has been married?
I'm going to go with 0.
3.
Oh, okay.
Yeah.
All right, I'll let you get back to court.
I have a confession, Josh.
Yeah.
Have
you been looking at the whole time?
I had to Google it myself, so I'm sorry.
Yeah, exactly.
But I did grow up with the Barbra Streisand. She sings Jenny Rebecca, that song, 4 years old. What a lucky, lucky girl you are.
Yeah.
I know that, and my name is Barbara, and some funny songs. I'm 5. I'm a big girl now. I'm 5. I remember all those from my childhood.
I'm going to answer the Gigi Bear's question.
Mm-hmm.
I do know Mary Tyler Moore.
Just from the song, Mary Tyler Moore?
Yeah.
I don't care
Yeah.
what you say about it anyway. I don't care about that. Yeah, I've heard of that as well. So,
yeah.
Do you know who John Wayne is?
I do.
He was Chuck Norris before Chuck Norris was a thing. Like he was the man that Chuck Norris. He filled that slot in our lives.
He made Chuck Norris who he was. Yeah.
So. Anyway, all right, Josh. Thanks for the call. Appreciate it. We're going back to
I'm
watch
just stalling them. Hopefully to get a verdict. You know.
We will. We're sitting at
in this wonderful trial that I chose.
This is 2 in a row for you.
It's terrible. I'm sorry.
Yeah, and we can go over the list of great mods again if you want. I think you did name them all.
I didn't name myself
from
on
the
purpose.
state of Georgia.
Josh, you're a great mod as well. Appreciate your help. Thank you, my friend. We'll catch you
right,
later.
see ya.
Bye.
Bye.
All right, we're going back to, we were going to go to Royal Oaks. Royal Oaks left us. So we're not going to do that. No, he's back. He's back. Let's see. No, they ended. They finished writing tickets for Arts Beats and Eats, which is a big fundraiser. Enforcement effort that they have up in that area, Royal Oaks. Why do I have Barbara Streisand coming up in my feed. I've never, man, that's crazy how fast that comes up. Do you want to go to the Sarah Boone document and review that really quickly? Because I'm hearing, oh, wait, one more. We'll go here while we wait, as long as this isn't a divorce case.
Maximum penalties, correct?
Yes, Your Honor.
And do you need me to do any other reading of the complaint?
No, Your Honor.
Not guilty plea will be entered on your behalf as to the misdemeanor. With the felony, do you want the prelim within time limits or outside of those time limits?
He's not in custody. We would waive any time limits, Your Honor.
All right, Mr. Davis, can you do September 10th at 2:30 or 2:45?
Cannot on jury trial on those dates.
What about September 11th?
I can in the afternoon if I can appear by Zoom.
I'm fine with that. Are you okay with that?
Yes, Your Honor.
Was somebody
1
asking
o'clock?
for the P.O. box?
That works.
Did
All
you
right.
get it?
September 11th at 1 o'clock. All right. So, Mr. James, you have that application. Can you bring that to me, please?
Jody, I will send you my P.O. box. Hold on. Or I'll have one of the mods do it. There we go. Boom. Josh nailed it. And Red Pen, both
I'm
of
going
you.
to double check to see how much money you have posted.
I'm going to be looking for the, give me just a second. I'm going to look for the document from Sarah Boone.
Just $1,000.
What county was she in again? Not Sarasota. She's in
You
Orange
know,
County, right?
All that information, but they wrote it down. You're going to schedule an appointment so we can talk.
Mr. James, you're going to need to put down $250. When can you do that?
Monday?
Monday?
Yeah, I can stop back up
That would be great.
after my probation.
Okay, so I'll say due by July 27 at 4 p.m., okay?
Okay.
And then it will be $50 a month after that.
Yes.
All right? Thank you, Mr. Davis.
Yes, Your Honor, thank you.
I appreciate it. And actually, it's September 11th, it's a prelim. Yep, okay.
It's not all right. Natasha, she'll schedule you up to meet with me, okay?
Okay.
Stay out of trouble.
Stay out of trouble.
All right, thank you. Mr. Lovedoll.
All right. All right, Don, you want to come on up here, Don?
Don, front and center.
I have the Polk County District Attorney's Office here for a probation review hearing. I'm just going to tell him that we don't need him unless he wants to hang out. Is this DA Kemp? Well, he's not speaking or seeing, so we'll just move on. Victim witness. Okay, victim witness. I have a plea before I get to Mr. Gaffney, and then I will be doing the probation review hearing. I appreciate victim witness appearing for the probation review hearing. We will go on the record in the matter 25 CF 28, State of Wisconsin versus Don Lovedoll. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Lovedoll in person with his counsel, Nicholas Davis. We're set today in this matter for a plea hearing. The parties have reached an agreement and the court has been handed a plea questionnaire waiver of rights form. Mr. Davis, can you please recite the agreement that's been reached?
I can, Your Honor. I believe the agreement that's been reached is my client would enter a guilty plea to count 1 and count 6. It's my understanding that a PSI is going to be requested, with both parties requesting the PSI. I think at the last hearing, I was going to request an alternative PSI, depending on what comes back with the original PSI. I don't think there's any objection on that. And my understanding is the state was going to be capped at the PSI, the recommendation of the PSI.
Is that correct, Mr. Schmidt?
Cap the state's recommendation?
All right,
Why?
so capped at the PSI, pre-sentence investigation recommendation. All right, Mr. Lovedoll, that's the agreement that you've reached?
Okay, I've got the Sarah Boone
I'm going to
document.
ask him, thank you, Mr. Davis.
Yes.
Okay, so I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
Did your attorney go over this document with you?
Yes.
And did he essentially go over it word for word?
Yes.
And did you understand everything completely?
Yes.
If you didn't understand something, did you ask him to explain it to you until you did?
I did.
And is that your signature on the second page?
Yes.
You are pleading guilty to 1 count of manufacturing or delivering methamphetamine greater than 3 grams, but less than 10 grams, correct?
Yes. Yes.
And you're pleading guilty to 1 count of maintaining a drug trafficking place, correct?
Yes.
You're 72 years old. You can read, write, you understand the English language.
You know
no
better.
drugs, alcohol, or other medications in the last 24 hours, and no treatment for a mental illness or disorder, correct?
That's correct.
Did your attorney thoroughly go over with you what the state would need to prove your guilt beyond a reasonable doubt?
Yes.
Did he go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that plea questionnaire. Do you understand that you would be giving up these rights by pleading guilty?
Right to trial, right to remain silent, right to testify. I'm giving up those rights. Yes, you are. We're not going to trial, remember. Yes.
You understand you'll no longer have the right to a trial. You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up?
Yes.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes.
Do you understand that you're pleading guilty to felonies? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
Do you understand as to count 1, delivery of methamphetamine, the state would have to prove on or around February 10th, 2025 in Burnett County, Wisconsin, you delivered a controlled substance, to wit, methamphetamine, in an amount of more than 3 grams, but not more than 10 grams. Do you understand what the state would have to prove?
Yes.
Do you understand that this is a Class E felony, and upon conviction, you may be fined not more than $50,000 or imprisoned not more than 15 years or both?
Yes.
Do you understand that as to count 6, maintaining a drug trafficking place, the state would have to prove on or around February 25th, 2025 in Burnett County, Wisconsin, you knowingly kept or maintained a building which is used for delivering controlled substances in violation of Wisconsin law? Do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction of this Class I felony, you could be fined not more than $10,000 or imprisoned not more than 3.5 years or both?
Yes.
Do you understand that the agreement calls for the court to order a pre-sentence investigation report and your attorney wishes to order an alternate pre-sentence investigation report? Do you understand that this court is not bound by either of those recommendations?
Yes.
I thought
those reports will provide a whole lot of information about
the
you,
state was
about
limited.
your life, about any criminal history you have, about this crime, and each of those reports will provide a recommendation as to sentencing in that document. Do you understand that I, the court, I am not bound to follow either of those recommendations?
Yes.
Do you understand that per the agreement, the state is capped at the original Department of Corrections pre-sentence investigation report for that recommendation?
Yes.
Do you understand I'm not bound to follow the recommendation or argument of the state?
Yes.
Do you understand that I'm not bound to follow the argument or recommendation of your defense?
Yes.
Do you understand that I am free in my discretion to sentence you to what I believe would be an appropriate sentence based upon the totality of the circumstances, all of the facts, all of the information in front of the court? Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney, that original charging document that has a bunch of facts in the section called the probable cause section, where it basically says what happened and why you were charged with these crimes?
Yes.
For the most part, are those facts accurate?
It's all the video. Yes.
I'm not going to have
It's
you
on
say
the
that
video.
every fact is accurate, but for the most part, are they accurate to those two charges you're pleading guilty to?
Yes.
Are you pleading guilty because you are guilty?
Yes.
He doesn't want to do this.
Do you have any questions for the court or your attorney before I proceed?
No.
Mr. Davis, did you go over the criminal complaint, in particular, the probable cause section with Mr. Lovedahl?
Your Honor, we did that, and we have gone through all the discovery, all the video footage, audio that was on the video, all the discovery. My client is a smart guy. He'd gone through that privately and in my office multiple times. And I am stipulating to a factual basis, Your Honor.
Thank you. Mr. Lovedahl, has anyone made any threats or any promises to you for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing.
Yes.
And voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he discussed with you the evidence in the case, also known as discovery?
Yes.
Has he discussed with you any potential legal defenses or a lack of defenses you may have in this matter?
Yes.
Has he discussed with you that it is your right to go to jury trial?
Yes.
And you're waiving that right?
Yes.
Have you discussed with your attorney any possible facts and information that you know to exist about this case?
Yes.
Any other people that may be involved or be more culpable? Did you discuss that with your attorney?
Yes.
Did you discuss any other alibis or any other defenses that you believe exist in this case with your attorney?
Yes.
Did you discuss everything that you know to exist about this case to your knowledge with your attorney?
Yes.
Are you satisfied with his services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No.
Mr. Davis, is there any reason why the court should not take a plea from Mr. Lovedahl today?
There is not, Your Honor. I have spoken with Don not only today, but prior to today and last week. I've seen him in person. He's lucid. And as an officer of the court, I believe he's entering his plea knowingly, voluntarily, and intelligently. And I have not put him under coercion or duress or forced him to do anything. No one forces Don to do anything, actually. Don makes his decision all on his own. And that will be my record, Your Honor.
Thank you. So, Mr. Lovedahl, you are entering your plea freely and intelligently, telling the court you do fully understand everything you're doing today, correct?
Correct.
And voluntarily.
Yes.
All right. Any questions before the court asks for your plea?
No.
As to count one, manufacturing, delivering amphetamine, methamphetamine greater than 3 grams, but less than 10 grams, how do you wish to plead?
Guilty.
As to count 6, maintaining a drug trafficking place, an I felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 counts. A judgment of conviction will be entered today. The court will order a pre-sentence investigation report, long form. Agent does not need to appear, but should be readily available by telephone in case any questions arise. As to whether or not to revoke bond, argument, Mr. Davis.
Your Honor, I know you didn't make an order, but I was going to ask the court not to revoke bond. I think the court may have tipped your hand saying that you can do whatever you want, but because there's going to be a plea here, that there is a good likelihood that you were not going to. I spoke with District Attorney Schmidt today, and he'll correct me if I'm completely wrong or out of line. I don't believe that the state was going to make such a request today either. The reasons: no bond violations. Case has been pending for quite some time. Don's followed all the rules that you ordered him to follow. When he has to be here in court, Don is here in court. And there's no bond violations I know of. 72 years of age. I know that he has the property here in Wisconsin, but also has his residence in Minnesota. And those would be my reasons, Your Honor. So there is a contact, a connection to this county because of that. Thank you.
Mr. Schmidt?
The reason I'm not asking to revoke bond is the court initially set a bond at $50,000. He couldn't post it. He convinced the court to reduce it to $15,000. He did post that, meaning there's $15,000 on there, where if he doesn't come to court, he loses that. And that is a lot of money, not just for anyone, but for him. Additionally, since he posted the $15,000 in March of 25, he's made all court appearances.
Thank you. The court will not revoke bond. We do need to set a plea and sentencing date. How long, Mr. Schmidt, do you believe that the sentencing, how long do you believe the sentencing will take, including your argument with a guesstimate of Mr. Davis's, et cetera?
Hour or less.
Hour or less?
I would ask for at least an hour, between an hour and 2 hours. I'm going to have Don. I know Don will want to give an allocution. I know his daughter and grandson will be here. If the court would even allow them to testify or present any evidence.
October 5th at 9:30. I can give you 2 hours.
Judge, I know I'm out that week. I'm out.
Are you going to do the alternate with the PSI being ordered, or wait until we receive the PSI?
I was going to wait till I receive it. There may be no need to have it, depending on what the PSI is. I do know that at least the person I've been using, Miss Andrea's, $6,500 now for an alternate PSI. And so if I can help my client avoid that kind of cost, I certainly will try to do so. He's not independently rich, but that may be my reasoning, Your Honor.
Thank you for letting me know that. That's a business I'll probably get into.
Yes, and I will join that business with you too if you don't want to be a judge.
All right, I can do September 25th, 1:30 to 3:30.
Yes, I can be here.
All right, September 25th, 1:30 to 3:30. All right, Mr. Lovedahl, you can come and get your notice, and then you're free to go. If by chance, Mr. Davis, we do need, or you do need an alternate PSI, we can move that date if we need to.
I sure hope we don't, and I would let the court know immediately on that, Judge.
Okay, thank you.
Thank you very much.
Thank you, we're adjourned.
All
right, thank you.
Mr. Gaffney?
Your Honor, we're gonna bail and go talk about Sarah Boone really quickly, if that's cool.
I'm doing the rest of the afternoon.
Unless it's really interesting.
We will go on the record in the matter 25 CM 105, State of Wisconsin versus Jordan Gaffney. The state appears through Polk County District Attorney's Office by video conferencing capability. We do also have Department of Corrections Agent Leah Lineweber.
Okay, we're gonna skip. All right, it didn't reach out and grab me, so we're gonna skip it. We have a document right here to review a little bit on. Let me see if I can show you the timer at the same time, so you guys can see how the deliberations are going. That's not it. We need. Camera 2 is going to be camera 3. There we go. Oh, doesn't work. Never mind. I take everything back that I told you. We can only go right here because I'm using the timer that has the timer on it. I'm using the screen that has the timer on it to read this. My bad. All right, what this is a new filing just this month from District Court of Appeal, Florida 6th District, answer brief of the state. And the table of contents really, it tells us what we have here. We're obviously not going to go through all the citations. There are 45 pages of filings, but Sarah Boone wants a new trial. Sarah Boone wants a new trial for a couple of reasons, and this is the response to that. And if we look here, it's broken down into four parts for arguments against her getting a new trial. This is the state saying, no, this should not be allowed. The first one has to do with the trial court not abusing, this is important, its discretion in limiting the appellant's opening statement when it precluded the appellant from using demonstrative aids. Remember, she wanted to use stuff, and they said no. Number two, the issue is unpreserved for appellate review. When it's unpreserved, that means it was not objected to in a timely manner, and it was not preserved for the record. This trial court provided an adequate remedy for the discovery violation. So they're admitting it was a problem. It was unpreserved. We fixed it anyway. Not an issue. Number three, the trial court did not abuse its discretion by instructing the jury on the initial aggressor exception of self-defense. And number four, the trial court did not abuse its discretion. Are you seeing a common theme here? Its discretion in allowing Dr. Werner to testify about her opinion. The three issues where it has discretion, where the court has discretion, that seems like part of the weakest argument you could bring up. It's literally where the law allows the court to decide. It's one of those, you could go either way on that, right? This is not, it's not, you can choose, Judge. It's your court. How do you want to run it? You can run it this way or you can run it that way. And if they choose one way, you can't be like, hey, that's no fair. You didn't run it the other. Discretion is in the court's discretion, not in the defendant's discretion. So, word of the day. We already had a word of the day. I think it was defenestrate or something. I don't know. But discretion is the second word of the day. But the appellee generally accepts the appellant's statement of the case and the facts, but would note the following facts in support of an answer brief. So basically, they got it mostly right in their filing, but here's our viewpoint. The appellant was charged with second-degree murder of George Torres. This is the suitcase. You remember the video. The state filed a combined motion to strike the notice of intent to rely on the defense of battered spouse syndrome, motion to eliminate, the motion for examination by a state expert. As to battered spouse syndrome defense, the state argued the notice was insufficient because it did not include any particular facts which would allow Dr. Julie Harper to opine that appellant suffered from the syndrome. The state moved to exclude Dr. Harper's testimony as it would be based on inadmissible hearsay of the appellant's statements and argued that the appellant should be precluded from mentioning battered spouse syndrome in her opening statement. Remember, she couldn't bring that in. The state noted that the appellant had previously told law enforcement that she accidentally left the victim in the suitcase overnight, and that battered spouse syndrome testimony is not admissible if the defense was that the killing was an accident. It does not appear that the notice of intent to rely on the defense of battered spouse syndrome was included in the record on appeal. And the state requested the appellant to submit an examination by state expert. So this is her whole appeal, right? You get one shot at this. That word of the day was innocuous. Yeah. I'm just going to scan through here and see if there's anything that jumps out. The motion in limines to exclude the testimony. Let's see. Appellant told, the state noted, based on the depositions of Dr. Harper and state expert Dr. Tanya Werner, the appellant, that's Sarah Boone, told both experts that because of past violence between her and the victim, she had a generalized fear every day that the victim would cause her serious bodily harm. But on that day of the killing, the victim did not take any overt action that made her believe he would cause her serious bodily harm or death. Instead, appellant's version of events was that the victim, after drinking all day, suggested a game of hide and seek. The victim hid in a suitcase, and the appellant saw him do so and decided to zip the suitcase shut while the victim was inside. They were both laughing. Appellant asserted the suitcase was not completely shut, and the victim could poke a couple fingertips through. The victim could not breathe and became angry. Because the victim was angry, appellant became angry. The situation reminded appellant of past violence where she was unable to breathe, and she wanted the victim to feel what it was like for her to choke and not be able to breathe. And she hit the victim's fingertips with the baseball bat. Having hit the victim, the appellant believed he would kill her The appellant flipped the suitcase right side up and believed the victim would let himself out, and the appellant did not intend to kill him. So it was an accident. A game gone awry. And you can remember those heartbreaking videos. Sarah, Sarah. Yeah. That's my name. Don't wear it out. At the court hearing, the court asked for a factual basis Dr. Harper used to formulate her opinion. Defense counsel answered that it was based on their interactions with the appellant. When asked what overt act gave rise to self-defense, the defense counsel responded that the evidence of an overt act had come from an appellant at trial. Defense counsel agreed that appellant had to testify before Dr. Harper, so she had to take the stand to make this even possible, and that she had to present evidence of an overt act. And the defense counsel argued that the situation was not appropriate for a pretrial ruling. The state responded unless they were saying the testimony will be different at trial, it was asking the court to prevent the defense from presenting anything about battered spouse syndrome in the opening statement. Defense counsel argued that it was not the responsibility of the defense to present their case at a pretrial hearing, and that the court was forcing them to disclose what our view of the overt act is. Yeah. There's an affirmative defense where you can say, this was self-defense. I'm asserting my right to defend myself. That I'm asserting that's something you have to testify to. That has to come in. But once you testify and once those elements are met, saying I did this because I was in fear for my life, and I've met the qualifications for self-defense, then the burden shifts on the state, not on the defendant, to then prove that it was not self-defense. In this case, she's trying to prove something that didn't happen by saying, oh, we were great that day. Everything was fine. We were just playing a game and it went wrong. And then I got angry and I didn't let the game end and it killed him. So, all right. I'm not going to read it. I'm not going to read it all. This document is available over as the gavel drops, if you want to read the whole thing. 45 pages of the state telling us that Sarah Boone is not the greatest thing since sliced bread is good enough. Another thing in mod chat you didn't see. Greener's is sending me stuff. When it comes to court, Judge West is still out. Let me get the counter back up. Camera 2 should be back on camera 6. Yeah. Let's see if we can get the counter fixed. Give me just 1 second. So an hour and a half. Roughly. There's our timer. That's where I want it. There's our timer. Let's listen to the judge a little bit more, see what she's doing right now.
Guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life?
Yes, Your Honor.
You will no longer be able to vote in any election until your civil rights are restored?
Yes, Your Honor.
Do you understand the state would have to prove as to count 1, possession of a firearm by a felon, that on or around December 21st, 2025 in Burnett County, Wisconsin, you possessed a firearm having been convicted of a felony in this state? Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $25,000 or imprisonment of up to 10 years or both?
Yes, Your Honor.
Do you understand that it's free to argue, but even with that, I'm free to decide whatever the sentencing is that I feel is appropriate based upon the facts of the case.
I understand, Your Honor.
Okay, I'm going to mute her for a second. Are you talking about the Rose Petal murder? Yeah, I believe he gets a court date to see if he gets a new trial. And Rose Petal was crazy. Oh my goodness, Rose Petal was crazy because we had a defendant take the stand and just calm, cool, and collected walk us through step by step committing the murder. Just like, whoa, like more details than we'd ever seen before. That was crazy. So yeah, I don't know what the reason we need sad piano for that. I don't know what the reason was for the Rose Petal murder to go back to court. Maybe Amber can tell us in chat. But the idea that goes back to court, there was no question in my mind that he was guilty, and I'm curious what that was. Not guilty to the murder, but to the bad stuff. So Hughes guy is saying that the state can't have it both ways. Okay, we'll turn off the music. I can't think through that. I have a question. How many times can a convicted individual request a new trial? Seems like this is a high cost. I think they have a couple options for it. Obviously, the appeal is the standard one, but there may be situations where an appeal is presented, is turned in, denied, and then due to circumstances that have arisen, say, for instance, you get convicted, you're in Massachusetts, you get convicted of whatever your crime is up there in Boston or around that area, and you lose your appeal, and then you find out that the lead investigator on your case had texted some terrible things about you during the investigation and how he disliked you personally from the moment he saw you, even before he knew you were the suspect, and just he was out to get you, or something like that. This sort of thing, obviously, it's an outlandish example that would never happen in real life, right? I'm just trying to set up a scenario where, you got some rogue lead investigator that just puts all his intrusive thoughts down in chat with all his police buddies, and talks about terrible things and calls people names and everything. And that would present a bias that I think would open the door in that figurative example. Obviously, I've just picked a state out of the hat that you might have reason to then go back to the court and say, we would ask now because of this for a new trial. So I didn't say any names. I was really good, Sarah. I was really good. Yeah. Let's see. Let's see if we have anybody else that we can jump in on for court. Expedited calendar, that just means calendaring. Judge Stevens is doing his murder trial. Have another spam call. Hello?
Hello.
Hello.
Hello, sir. Good afternoon. By the way, this is Elaine, and I work in the booking department here at Go Vacations. I'm calling you in regards to a large amount of travel credit you haven't found yet. My job is to close out all expired accounts, but when I saw how much credit you have available, I wanted to check in with you because I didn't feel
Good. Closing it out with so many. Yeah, okay. I know the script, but I can hardly understand what you're saying.
I'm calling you in regards to a large amount of
travel credits.
credit.
And it's your job to close out the
Yes.
account. But when you saw how
Yes.
much accounts I had, you didn't feel good about closing it out without calling me to give me the opportunity. Okay, I understand. I understand what you're saying. Now go on. Go on.
Okay. Stands up. And sir, also sir, any transfer fees, alright sir. This package starts with our VPN locks. So now you have places like Bronson, Hilton Head, Vegas, Smoky Mountains, Orlando, and Myrtle Beach. Just to name a few. And last but not least, we're giving you a fully customizable cruise for 4, 5, or 7 nights on either
I
Royal
take the 7.
Caribbean. All right. So, and also, sir, Royal Caribbean, Norwegian, or Carnival, and you get to choose any exciting destination of your choice, sir.
Gonna
So
do
you can choose it.
Caribbean for 7 days on the Grand
Yes,
Canyon.
yes, sir.
Awesome.
You want it, sir?
Yeah,
Okay.
where
And
does it launch from for the Grand Canyon cruise?
okay. So, and also we are adding 2 round trip airline tickets, sir, to get you to whatever port you want to port out of. Okay.
So it would
So
go up
you
from
can choose.
California up the river?
Yes, sir.
Okay.
So it looks like, sir, because of our credit, it pretty much pays for everything. The only thing left would be rolled over booking and processing fees, sir. Okay. So stay on the line, sir, because I will connect you at our specialist. Okay.
Oh, specialist? I think I have to. Yeah.
Remember in the beginning when we started 110 years ago?
I'm allergic to music. Is there any way you could turn the music off? I'm allergic to music, please. Can you turn it off? I don't know what this music is. It's like I'm listening to a circus. Hello? Is anybody there? I was supposed to speak to a specialist. I'm just hearing music. Yes, this allergy is common. I'm gonna try this. We're holding. I think I'm on hold, and they're just playing music.
Hello?
Hello?
Yes, hi, this is Matt. I just came on the phone to further assist you. Did you have any questions about the vacation package, sir?
I think it was Anna that I was talking to about the different options for vacations, and we were.
Yeah, and was she kind of polite to you, sir?
She was. I have to admit, I couldn't understand what she was saying.
Oh, okay. All right, I apologize about that. Well, I do come on the line. So, my name is Matt Price. I'm in Fort Lauderdale, Florida, so you do have reference to the phone call. So where can I help you out? I mean, my job is to answer any of the questions on this live call.
She had mentioned something about a Grand Canyon cruise and Royal Caribbean. I don't think she said Disney or something, but I had a concern about one of the cruise ships. I've tried a cruise before, and it didn't have on-ship plumbing. They had like they had like a little outhouse thing with the hole at the back of the ship, and I don't know what amenities are on the new one. Are these like, do they have full like plumbing stuff involved?
Yeah, I mean, we're not sending you on like we deal with like 4 or 5 star properties, and you do have your choice of the Royal Caribbean, the Norwegian, Royal Caribbean, and Carnival Cruise Lines.
So no
So
outhouse.
yes, no, you're staying in nice vacations. Yeah, we're hired by the resorts like Wyndham, Diamond, Westgate, RCI, Marriott, Hilton, Hyatt. We have contracts with all the major cruise liners and all major all major airliners except for like JetBlue and Spirit Airlines just went out.
Do you guys work
so yeah,
with
you are staying
like the travel companies to I need like an Uber or Lyft to get to the
No. No, we don't have anything like that. No, nothing with Uber or Lyft, no.
Okay.
All right, so basically, I'm sorry, go ahead.
No, go ahead. I'm just trying to understand what it is.
Okay, so I'll just kind of start from the beginning. Okay, the only 3 ways that we're on call is basically if you had done a timeshare presentation, if you were a timeshare owner currently or in the past, or if you had bought a vacation package that was not fulfilled.
I went to a timeshare presentation. Honestly, they had like a pickle bar on the site, and I spent more time there. I'm not sure if they had sold me something or if it was just an offer, but I didn't leave with any papers.
Okay, well, if that's in the system, basically that's through the resorts. Basically, when you did that presentation, that would be a reason why you did receive a $2,500 credit. Simply, we're hired by the resorts to fulfill and book the trips. So basically, that's why we're in contact. Basically, we apply that $2,500 credit to our promotional package, and we offer it to you. And then we just take care of a small booking and processing fee. And then from there, we'll send you out all this information on the live promotional call, so you get your welcoming email with your vacation package that never expires.
So you're with a timeshare company?
We don't do timeshares. We're like a vacation club. Differences like timeshares, they're like annual contracts, and then they also have like monthly maintenance fees. Vacation club, we just see if you want to join into like highly discounted traveling, but there is no purchase necessary to join. Basically, on your first 4-day, 3-night amenity tour, we do have Vegas and Orlando. You're in Utah, correct?
I was trying to get back in touch with them because the pickle bar, they had a spicy maple bourbon pickle. I've been looking everywhere for those pickles and can't find them anywhere. And
yeah, I don't know, man. I don't know what to tell you on that one.
Yeah,
Google it. Maybe you can make it on your own.
Yeah, maybe.
Google knows everything. I worked 20 years. I ran restaurants, man. So like, yeah, you could probably Google it and find it.
Serious?
So.
Were you like a cook or your management side?
That started out in 04, 07. I opened a restaurant like north of Tampa. Then I got part of like a franchise development. I opened like 5 successful restaurants, breakfast, buffet. I did like 5 different restaurants. So like, I'm all around, man.
Have you heard of the Breakfast Company down in Sarasota?
No, I'm on Fort Lauderdale side.
Oh, okay, yeah. It's an amazing breakfast. Last time I was down there, it was just incredible. But okay, sorry,
okay. I
got sidetracked.
Yeah,
I have ADHD and I have a hard time carrying conversations all the way through. So.
Oh, okay, that's okay, Dwayne. No problem. Oh, well, I'll go right back to the vacations. I mean, your cruise is going to be a 4-day, 3-night up into an 8-day 7. It is good for you and another guest. We do include 2 round-trip airline tickets, especially in Utah. We do have 7 ports across the country. So we'll get you to the port and safely back home. You do have Eastern, Western, Southern, Eastern, Southern, Western Caribbean, Dominican Republic, Jamaica, Bahamas. So you do have a lot of trips and destinations. Also, I'll put a 4-day, 3-night with airfare. So in total, you'll receive 5 vacations and 4 round-trip air.
Would you be able to choose for me? Because I'm like, if I go to Baskin Robbins, there are too many options. I'll stand there all day and ice cream will melt. But if someone just buys one for me, it's good. Could you like choose?
Your trip, okay. Yeah, they got 31 flavors, man. I'll go get you the mint chocolate chip.
That's
cool
a
that?
good one. I would do that. I mean, like,
Yeah.
it sounds like all these chips are amazing. I don't know if I could ever decide on one.
Yeah, I mean, it's up to you, man. You get to go wherever you want. So, I mean, you have 4 other people you can travel on your first one. Maybe you get with your friends or family and decide to they'll help you put it together. So,
I got 400 people I could bring.
400?
Yeah,
well,
they're listening right
3
now. We're live on YouTube. This is Recovery Addict. You call the Recovery Addict channel. My name is Scott. I'm on
Recovery
YouTube right
Addict?
now. Yes.
Oh, cool. Hey, I'm in recovery too, man.
Wonderful.
My sobriety date.
What's your date?
My sobriety date is February 11th, 2024, man.
Matt, that is awesome.
So
That was
Yeah,
awesome.
I got 2 years and 5 months, man.
One day at a
So,
time.
yeah.
Dude, that's gonna be 20 before you know it.
Yeah, man. Yeah, I'm into it. You know, I'm very active with the community, and you know, yeah, I love my sobriety, man. I go to meetings. You know, I got a sponsor. I have sponsees, and you know, I'm doing the deal, man.
My
it's a great
chat
blessing.
is saying congrats, Matt. Good for you, Matt.
Awesome, man. Awesome.
Matt. Congrats. I have to tell you, Matt, I'm not gonna buy, but I appreciate your
All right.
time. Thank you very much, and good luck.
All right. God bless you, man. Take care.
You
Have
too.
a great day.
You too. Bye. I felt bad now. That is awesome. We need to blow the party button. Oh, that's the police button. That's different. Yeah, we'll do this one. That is awesome. Way to go, Matt. I like to say this is a scam. You can actually go on vacation doing this. The scam is how they hook you, how they tell you you have these credits. Everyone has the same credits. It's the same program. The availability is questionable about the dates and you know what you get for that money, but we all feel bad. No, I think that was probably the best call of his day. We talked about his restaurants, his successful restaurants. We talked about a little bit about. I know I was looking forward to the Grand Canyon cruise headed up the river from California. That would be amazing on Caribbean. I mean, why haven't I done that yet? That's where the money's at. All right. Still waiting. Let's keep looking and see if we can find something else to entertain ourselves. Those calls are getting fewer and fewer, more and more seldom. They're happening less often. That's what I'm looking for. So maybe I'm falling down the list of gullible people in their phone book. I'm just not seeing courts. I've got fishing videos coming out my ears, logging videos, Barbara Streisand videos. I'm just not seeing many courts that are lobster, like the lobster ones. You guys seen anybody? Who is Dwayne? Dwayne is someone who had my phone number many years ago, like dozens of years ago. And I've been getting these calls ever since. It has been years. And eventually I just decided that, let's watch a logging video. Eventually I just decided that that instead of just being upset and angry that I'm getting these calls and I cannot make them stop, no matter how many do not call lists I'm on and how many times I asked to be removed off the list, I decided to roll with it a little bit and use a little bit of their time while they were using a little bit of mine. And that's where it happens. I'm missing our foliage coverage. Yes. I want Scott to narrate a logging video. Deep in the forest. No. All these videos you mentioned are great. Unfortunately, they're not my videos, and me showing them could get me a copyright strike. Bothell Municipal Court Live. There's one. Let's look at that. Up. Bothell Municipal Court Live. Let me do a quick peek and make sure this is what it says it is. It is. City of Bothell. Let's go there.
Judge,
You know what?
Judge, can you hear me?
I can hear you.
I can hear you. I can't hear him. So what I'm going to do is I'm going to go into my chambers.
Judge, I'm
and
not
that
a
might
cat.
work. So give me a second.
Okay.
All right. So Ms. Lardy, you can still hear me?
Yes, we could hear you.
Okay, great. Thanks.
Where is this at? You swear you heard
Sorry, I'm
Bothell?
multitasking. I met Mr. Vargas. I was looking at another case when I said Garcia, so it's Mr. Vargas who's been here a while.
Oh, thank you, Mr.
Sorry
Johnson.
about that, Diego. I was just.
Oh, no worries.
I'm too old to multitask.
Me too.
Hello.
Attorney Vargas is here. That's a good attorney name. Play on Crime, thank you very much. I answer all the calls. Oh, you're thinking about that guy who chops wood on TikTok with the axe? And
folks, while everyone's getting on,
no shirt.
It's going to be kind of moderately free for all. I'm going to defer to the court. So if you want to advise the court when you're ready, I anticipate that Mr. Vargas will go first, but I'm defer to the judge because I have no idea who's on, who's ready, because of this kind of circumstance. So just give you a heads up before we get started.
Free for all on Zoom court? Let's do it. I'm here for it. Surprised I know. I'm a subscriber. I'm interested in the shape of the axe.
Okay. Let's see if that works.
Judge, can you hear me?
I think the judge is a Dapper Dan man.
I can hear you, Judge. Can you hear us?
Yes, now I can hear you. I'm so sorry about that. Okay, go ahead, Mr. Johnson.
Just a couple things. One, Mr. Vargas's case is ready, but just to give the court, I just told everyone we're going to have to go kind of impromptu and defer to the court. So whenever you want to call cases, because I can't tell who's up. So Mr. Vargas's case is ready.
All right, Mr. Vargas.
Good afternoon, Your Honor. Your Honor, for the record, Diego Vargas on behalf of Jody Schwartz, who's present via Zoom today. And this is cause number 6A0155349. The parties have reached an agreement. There's a guilty plea form in the O-Court portal. And I believe a judgment and sentence that's available also. And I think the parties are ready to proceed to entry of the plea, Your Honor.
Okay. Ms. Schwartz, can you hear me okay?
Yes, I can.
All right. I've got in front of me what's entitled the Statement of Defendant on Plea of Guilty. It says that you're 56 years old and you went through high school. Did you have an opportunity to go over this with Mr. Vargas?
Yes, I did.
Okay. You're currently charged with the crime of DUI. Do you understand the nature of that crime? And what I mean by that is, do you know what the elements are and what the city would have to prove if you went to trial?
Yes, I do, sir.
Okay. As somebody who is charged with a crime in this country, you have a number of very important constitutional rights. And I went over that at your arraignment, but they are the right to a speedy and public trial by an impartial jury, the right to remain silent before and during trial, the right at trial to hear and question witnesses who may testify against you, the right at trial to testify and to have witnesses testify for you at no expense to you, the right to be presumed innocent unless the charge is proven beyond a reasonable doubt, and the right to appeal a finding of guilt after trial. But do you understand that by entering this plea that you're waiving or giving up all of those rights?
Yes, sir.
Okay.
I do.
And do you understand that there is a minimum, well, first of all, the crime of DUI is a gross misdemeanor. That means that the maximum penalty is 364 days in jail and a $5,000 fine. And there's also a mandatory minimum sentence on this case of 1 day in jail and a $350 fine. Do you understand that?
Yes.
Do you understand that even though there's
around.
an agreement between your attorney and the city about what I should do as far as sentencing, do you understand that I, as the judge, don't have to follow that? That I can give you any kind of sentence within the maximum allowed by law, and it's not a basis for you to all of a sudden say, well, wait a minute, now I don't want to plead. Do you understand that?
I do understand.
Okay. And you also understand that you can be placed on probation for up to 5 years, and during that time, you can be made to do several different evaluations. You can pay cost, fees, and assessments. There could be restitution, all the things that are associated with being on probation. Do you understand that?
Yes, sir.
Do you also understand that if you're not a citizen of the United States, that a plea of guilty is an offense punishable as a crime could have immigration consequences? And were you able to talk about that with Mr. Vargas?
Yes.
Okay. And looks like and do you understand that there's monetary penalties that are mandatory along with this crime? Do you understand that?
Yes, Your Honor.
Okay. And a prior offense is one that's listed as being within a certain amount of time. Do you understand that in lieu of the 1 day in jail, I could, at my discretion, allow you to serve 15 days of electronic monitoring?
Yes, sir.
1 day in jail is equal to 15 days at home confinement?
Paragraph 11 says, on January 25th, 2026, I drove a motor vehicle in Bothell, Washington. while my ability to drive was affected to an appreciable degree by an intoxicating liquor I had consumed prior to driving. Even though you didn't write that statement, are you adopting it as your own, and is it a true and correct statement?
Yes, sir.
Okay. Keeping in mind all of the important constitutional rights you have, what is your plea to the crime of DUI? Guilty or not guilty?
Guilty.
And has anybody made any kind of threats or promises to cause you to enter into that plea?
No, sir.
You believe you're making that plea freely and voluntarily?
Yes, sir.
Do you have any questions for your attorney or the court prior to me accepting your guilty plea?
No, Your Honor.
Okay. I will accept the guilty plea. I'll find you're making a knowing, intelligent, voluntary decision. Do you understand what the charges are and the consequences of the plea? And there's a factual basis for the plea. So I'm going to sign that.
Yes.
So the first thing I'm going to do is I'm going to talk to the prosecutor, Mr. Johnson. Anything further with regard to sentencing?
No, Your Honor. Ms. Swartz has taken many affirmative steps already, so I have very high expectations. So, but other than that, nothing else to add.
And I'll turn to you next, Mr. Vargas.
Thank you, Your Honor. We are asking the court to follow the agreed recommendation. We do think it's fair and appropriate. I can tell you that Ms. Schwartz did complete the assessment. It's been filed with the court. She also completed the ADIS and victim panel and also the early intervention treatment program that was recommended. All of that has been filed with the court. I know that she's very sorry that this occurred and that I don't think you'll see her again. She does have a prior that's quite old, but we are asking the court to allow her to do this. We're asking the court to follow the recommendation, and she'd prefer to do the 1 day in jail versus the 15 days of electronic home monitoring. And she would ask the court to allow her to report to do that day in jail within the next 30 days if the court would allow her to do so. And I believe that it's at the Linwood jail. Is that correct? Is that where the city has the contract with?
No, Kirkland and Snohomish County.
I'm sorry, to allow her to serve it at Kirkland if you may.
Okay. Let me check with my staff here really quick. Miss Heather, is it just Snohomish County Jail or can she serve that at Kirkland? Can you let me know?
It is only the Snohomish County Jail.
Okay.
Okay.
So is that still okay, Mr. Vargas?
It is, Your Honor. Thank you.
Okay. Ms. Schwartz, this is your opportunity to tell me anything that you would like prior to sentencing. You're not required to, but if there's anything you'd like to say, I'd be interested to hear.
I just really regret my actions. This is definitely a test of what people are made of. Been embarrassed, disappointed, of course, and I know that we will not be here again. So I just thank you for your consideration. Sorry.
No, you don't need to apologize. It's a weighty thing to go through something like this. So I appreciate your words. I will say that I am happy that you are both taking it seriously and have done everything that you were required to do ahead of time. And the reason I say that is because I've known Mr. Vargas for a long time. And I was going to have some real questions for him about following this recommendation with prior DUI and with the accident. I was going to have questions about that. But I'm willing to follow the agreed recommendation because you've shown that you're taking it seriously, because you've shown not just, acceptance of responsibility. I think that's obviously one step of it, but doing the things that you knew that I was going to be asking you to do, I think shows a responsibility as well. And so I am going to follow the agreed recommendation. So there's 364 days in jail, with 363 suspended. So there's that 1 day to serve.
Okay.
There's a $5,000 fine with 4,650 suspended. That'll be suspended for 60 months. That's 5 years. We do things in months on these for some reason.
Okay.
So there's a $350 fine, $43 criminal conviction. Ultimately, it's going to add up to that $900 some dollars, $990.50.
It's definitely going to add up.
That we talked about.
It adds up a ton. Oops, sorry.
Well, are you working right now? If you don't mind me asking, your financial circumstances?
I am working right now. Yes.
So if when I set this up, did it at $50 per month starting next month, would that be acceptable to you? Would you be able to make that happen?
I can pay it all at once, sir.
Okay, I appreciate that. You know, what I like to tell people is I never know what's going to happen when they leave my courtroom, you know, and so I'll set it at $50 per month starting August 21st.
Okay.
Okay. So the conditions on you are that you can't drive without a valid license and insurance. You can't drive or be in physical control of a motor vehicle with an alcohol concentration of 0.08 or more, or a THC concentration of 5 nanograms per milliliter of whole blood or higher within 2 hours after driving. If a law enforcement makes a reasonable request for you to submit to a breath or blood test, you need to submit to that.
Okay.
If the Department of Licensing is going to require you to have an ignition interlock device on your vehicle still because of this conviction, you need to make sure that you comply with that. Have no criminal law violations. I'm going to put you on monitored probation for the 60 months. Monitored means you're not going to have to come in and meet with the probation counselor. And that's because of that work that we talked about ahead of time. You've done everything that I would ask you to do. I'm checking on here that you need to do the substance use evaluation and do the recommend treatment and the DUI victims panel, but you've already done those things. So I don't want you to think that I'm asking you to do another evaluation or anything. I'm requiring you to do them, but I'm giving you, for the record, you've already done those things.
Okay.
You know, and those have already been filed with me as well. And so I'm just going to put a little thing in here that says it needs to be filed within 15 days, but you've already done that.
Okay.
Okay, I need to look at something really quick.
Uh-oh. Ambulance turning down the other road by my house. College Station's where my son was for the last week, down in Texas, visiting family. Judge is whispering to himself. He has some very nice looking hair. Is that Lincoln? Is that like a bust of Lincoln there on the shelf behind him?
Okay. All right. I've gone ahead and I changed August 21st. Okay. Ms. Swartz, do you have any questions for the court prior to me signing this, or to Mr. Vargas? Is there anything that I've missed?
Your Honor, I don't think you missed anything. I would like to know if, because we're doing this virtually today, I can have her sign a copy and then file it with the court if you like me to.
Yeah, that'd be fine. I also need to do a commitment date. I did forget something. Okay. I tend to like to give sort of a sort of a date certain for a commitment date. I don't mind it being within 30 days, but sometimes in Snohomish County Jail, when you just sort of show up with paperwork that says, I want to serve whenever, I've had people that get turned away, and I don't want that to happen, Ms. Schwartz.
Okay.
Is there a date that works? If I were to say you need to serve it by this date, that would work for you?
You mean within the 30 days or?
Yeah, just within 30 days.
Let's see. So it would be, let's see, because we're getting close to August.
We are.
And I'm covering at work for vacations for the first week and a half of August.
Fine.
So, I mean, is there a certain day that you check into? Is it any day?
Let's just, you know,
like a Monday?
I think it'll be fine, and luckily Mr. Vargas can help you out. So here's what I'll do. In case you want to serve it on a weekend, what I'm going to do is I'm going to say
on a weekend. I would prefer not to be in the.
So what I'm going to say is, one day shall be served in the Snohomish County Jail by August 24th, 2026.
Okay.
So that'll hopefully, if for some reason you go to turn yourself in and there's a problem, Mr. Vargas can contact me and I can do a new order. Does that work?
Oh, that works.
Okay.
And that's just a matter of just showing up there and
with your paperwork, yes.
My paperwork. Okay.
Okay. All right. I've gone ahead and signed that, and unless you have any question, Ms. Schwartz, good luck to you.
Thank you very much, Your Honor. I appreciate it.
Thank you very much. Thank you, Mr. Vargas.
Thank you, Your Honor, and I'll have her sign that, and then I'll file a hard copy with her signature with the court.
Wonderful. Thank you, sir.
Thank you very much, Your Honor. Take care and have a great day.
You as well, sir.
Bye, Mr. Johnson.
Gracie.
And Your Honor, I think Miss Kim is ready with her case, Lysiana Gomez.
I've got family in College Station, Texas. And my son was there all last week. That's where he flew down.
Hello, Ms. Kim.
Yes, Your Honor. Good afternoon.
Which matter are you wishing to take?
Lysiana Gomez.
Okay.
She is present via Zoom. This is a motion to continue. She has an obligation to complete before accepting an offer. She's
Stefan.
working on it.
Stefan Crum.
This is a fairly new case, so it seems fine. Mr. Johnson, is there any objection to that?
No objection, Your Honor.
Okay. And you said that Ms. Gomez is present? Or is this a 3-4? Let's see. I'm looking at the...
She's present. Her video is not on. And
Oh, okay,
Miss
but you
Kim
can hear
is-
me. Okay, Ms. Gomez, can you hear me? Well,
I'm not sure. I did talk to her this morning, so I can proceed by 3.4.
that's fine. Okay. And I think I heard no objection from you, Mr. Johnson.
That's correct, Your Honor.
Okay, on the Lysiana Gomez matter, I will grant the motion to continue. I will find good cause and an excluded period, setting this to August 24th at 1:30 with a tentative trial date of October 12th. And, okay, I'm going to go ahead and sign that now.
Thank you.
Thank you, Mrs. Kim.
And I'll let Ms. Gomez know.
Thank you.
Your Honor, I'm ready on a quick continuance for Mr. Watterson. I'm appearing for Ms. Henderson from my office.
Okay, go ahead, Ms. Gardner.
Good afternoon, Your Honor. I am here with Henry Watterson. Henry, perfect. Your Honor, this is, I believe, subsequent to the court quashing a bench warrant. I've worked with Mr. Watterson in Issaquah before and asking the court to grant my continuance to a usual valley date on August 31st. And I spoke with Mr. Watterson prior to coming on the record and he authorized my signature.
Okay. All right. Any objection, Mr. Johnson?
No objection, Your Honor.
All right. Mr. Watterson, can you hear me okay?
Yes is the answer. We just can't hear you.
Henry, you need to get your phone a little closer to where the judge can hear you, okay?
No, he's muted. It's not.
I'm so sorry. I can hear you now.
Oh, you're okay. You don't need to apologize. Okay. Do you understand what's happening today, Mr. Watterson?
I'm so sorry. I can't hear you very well.
Okay. Do you understand what's happening here today?
Yes, I do.
And do you have any objection to the continuance?
No, sir.
Okay. I'm going to grant the motion to continue, find good cause and an excluded period. So your next court date's August 31st at 1:30 with a tentative trial date of October 12th, okay?
Yes, sir.
All right. Make sure to stay in contact with your attorney and then you have a good day, sir.
Thank you so much, sir.
Thank you. Thank you, Ms.
Bye,
Gardner.
Henry. You're welcome.
Bye.
And Your Honor, Madam Clerk just indicated they were able to get the other person into a breakout room. Can I get thrown back in there also?
Sure.
I think I had one more matter I was covering for Ms. Henderson on.
Okay.
Perfect. Thank you so much.
Thank you.
Good afternoon, Your Honor. I have Mr. Sanchez Antonio. It's a 3.4 continuance.
Okay, go ahead. Thank you.
It's 5A0961892. I do have explicit authority from Mr. Sanchez Antonio to appear today on his behalf, including for purposes of waiting speedy trial. This is a case that we're going to be asking to continue out until the blood comes back. Blood is still pending. It's a December case. I realize it's getting a little older, but based on discussions with my client, we will want to see the blood results before proceeding with trial on the case or negotiating further. I'm asking for September 30th at 1:30 with a speedy trial waiver commencing the same date.
Okay, thank you. Any objection, Mr. Johnson?
No objection, Your Honor.
All right. Based upon the blood results not being back yet, and that's obviously an important piece of evidence, I'm assuming you would like to discuss with your client. I'm going to grant the motion to continue, find good cause and an excluded period. So your next court date, September 30th at 1:30 with a tentative trial date of November 9th, and I'm signing that order now.
Thank you, Your Honor. Have a great rest of your afternoon.
You as well. Thank you.
Good afternoon, Your Honor. I am here for Mr. Flores Olivere with the 3.4.
Okay, go ahead.
Christopher Giadrosich on behalf of Attorney of Record Alistair DeBreo. This is a 3.4 authorized appearance. Mr. Flores Olivere has agreed to this appearance and has waived his presence here and is appearing through counsel. This will be a defense motion to continue to 9/9, September 9th at 1:30 p.m. and the motion's been uploaded.
Okay. Any objection with that, Mr. Johnson?
No objection, Your Honor.
Okay. I'm going to grant the motion to continue. I'm going to find good cause and an excluded period. So your next court date, September 9th at 1:30 with a tentative trial date of November 9th. And I've gone ahead and signed that order.
Thank you, Your Honor. Have a
Thank
good day.
you.
Thank you, counsel.
You as well.
I believe the Crum matter might be ready.
Your Honor, Mr. Buck is here for the Crum matter. I don't know if he's ready.
Okay, thank you.
Good afternoon, everyone. How are you? Thank you. I know it was a plea, so I know it was going to take a minute, so I wanted to make sure
It's
we're all
okay.
set to go.
Are you ready to go?
We are, Your Honor. Good afternoon.
Good afternoon. Okay, Mr. Crum, I need you to unmute because I need to have a conversation with you if you don't mind.
Got it.
All right. I have a document in front of me entitled Statement of Defendant on Plea of Guilty. Did you have an opportunity to go over this with your attorney, sir?
Yes.
It says your name is Stephen Gerald Crum. You're 34 years old. Is that correct?
Stefan Geraldo Ramon Crum.
It's
Yes.
Stefan. Okay, I apologize. Stefan. Okay. It seems like there might be a motion on this case, so I'll first turn to the prosecutor, Mr. Johnson.
That's correct, Your Honor. If the court would allow an oral motion to amend the current charge of DUI, excuse me, going through puberty, from DUI to one of negligent driving first degree, we have an anticipated plea. Thank you, Your Honor.
And is there also a motion with regard to clause number 667?
Yes, there is, Your Honor. Part of the plea agreement between counsel and my office is that I'll move to dismiss with prejudice the Buck's charge as well.
Okay. And go ahead, Mr.
Defense has no objection to either of those motions and will wait formal arraignment regarding the new charge as well, Your Honor.
Okay. I'll go ahead and grant that motion. Okay, Mr. Crum, you're now charged with the amended crime of negligent driving in the first degree. Do you understand what the elements of that crime are? That is, if this went to trial on that charge, do you understand what the city would have to prove in order to find you guilty?
Yes.
Okay. As somebody who's charged with a crime in this country, you have a number of very important constitutional rights. They include the right to a speedy and public trial by an impartial jury, the right to remain silent before and during trial, the right at trial to hear and question the witnesses who may testify against you, the right at trial to testify yourself and have witnesses testify for you at no expense to you, the right to be presumed innocent unless the charge is proven beyond a reasonable doubt, and the right to appeal a finding of guilt after trial. But do you understand by entering this plea that you're waiving or giving up all of those rights?
Yes.
Negligent driving in the first degree is what's called a misdemeanor. That means that it has a maximum penalty of 90 days in jail and a $1,000 fine. Do you understand that?
Yeah.
It also says here that there's a recommendation between your attorney and the city's attorney, but do you understand that I, as the sentencing judge, don't have to follow that? That I can sentence you anywhere up to the maximum authorized by law, no matter what anybody recommends, and it's not a basis by itself for you to try and withdraw your guilty plea. Do you understand that?
Yeah.
Okay. Do you also understand that I can place you on probation for up to 2 years, and during that time you could be made to do various evaluations. You could also be made to pay costs, fees, and assessments.
Yeah.
Okay. Do you also understand that if you're not a citizen of the United States, a plea of guilty to an offense punishable as a crime under state law could have immigration consequences, and were you able to discuss that with your attorney?
Yeah.
Coming down to paragraph 11, it says that on or about February 17th, 2026 in Bothell, Washington, I did operate a motor vehicle in a manner that was both negligent and likely to endanger property when I was involved in a minor collision, and I did exhibit the effects of having consumed alcohol. Even though you didn't write that statement, is it a true and correct statement, and are you adopting it as your own?
Yes.
Keeping in mind all of your important constitutional rights, what is your plea to the amended charge of negligent driving in the first degree? Guilty or not guilty?
Guilty.
Are you making this plea freely and voluntarily?
Yes.
And has anybody made any kind of threats or promises to cause you to enter into this plea?
No.
I will accept the guilty plea. I'll find you're making a knowing, intelligent, and voluntary decision, that you understand the charges and the consequences of the plea, and there's also a factual basis for the plea. I'll first turn to the prosecutor, Mr. Johnson.
Chair, this is an agreed recommendation. There's nothing really for me to add, so I'll just stand by the plea agreement. Thanks, Judge.
Okay. Mr. Buck.
Thank you, Your Honor. We're also asking the court to follow the recommendation. In addition to some potential evidentiary concerns here, I think part of the city's recommendation was based upon Mr. Crum having completed his early intervention treatment program. He was evaluated back, I think, in mid-April and finished that 2-month treatment program just, I think, a few weeks back. That program started with an ADIS followed by 8 follow-up sessions. He's also done the victims panel. I've gotten to know Mr. Crum, pretty well, Your Honor. I know that he takes this matter very seriously, as does his family, who supports him throughout this process. I know he's there with his father today, and we're just asking the court to follow the recommendation, Your Honor. Thank you.
Mr. Crum, prior to sentencing, is there anything you'd like to say to the court? You're not required to, of course.
I'd like to say I'm just glad nobody got hurt. Treatment's been really good. The classes went really well and smooth, and I think it's been helping out for the future.
Can you talk to me a little bit more about that? I am noting that this is the third sort of involvement in this kind of case. You were not necessarily respectful towards the officers, and so I think a lot of that probably had to do with the ingestion of the alcohol. And so I'm interested to know kind of what you've learned through the process.
Just to,
Sorry, I keep hitting buttons.
Slow down if there's an incident like this and not be so, I guess what's the word, like nervous or rushed,
Slow down.
I don't really
on a
get
DUI?
into these situations a lot, so they're kind of new and stuff to me. But I do know that going through the treatment and listening to everybody else's certain stories and stuff, it's really helped me kind of slow down and decide on certain things that I need to go do or shouldn't go do. And that would be like if I'm going over to, somebody invites me to go get a burger or somewhere to have a drink or something, you don't have to go do that. You can always just pass and go somewhere for breakfast in the morning instead or
I
something.
think the burger's mandatory, actually.
All right. Thank you very much.
Thank you.
Judge is not impressed with that answer.
Okay. I'm going to follow the agreed recommendation, and it's because you've put in the work, and it was more than just go to one class. It was sort of we need to change your line of thinking, because I think the path you were on was not great. And so I'm glad to hear that you've sort of internalized what's happening here. So I'm going to impose 90 days in jail, and I'm going to suspend all $90,000 fine with 700 suspended. That'll be for 2 years. I've granted the motion to dismiss the controlled substance charge. There's a $300 fine, a $43 criminal conviction fee. There's $10 there.
Judge is a pushover.
There's going to be some restitution you've got to pay in the amount of $400 to Bothell PD. Are you working right now, Mr. Crum? I'm interested in your financial circumstances in setting up a payment plan for you that'll help you towards success.
I just started my own business detailing cars, boats, RVs, I just started that within the
work.
last couple months.
Good work.
Okay, so starting a new business can be a little bit difficult. Okay, if I did $50 per month starting next month, do you think that's something you could swing with your new business?
I think so.
Okay. If you end up needing to adjust that, you can talk to your attorney and bring that as I'm happy to adjust that. I'd rather be set up success than put you in collections or anything like that.
Okay, thank you.
All right. So for the 2 years, you need to make sure that you don't drive without a valid license and insurance. Do not drive or be in physical control of a motor vehicle with an alcohol concentration of 0.08 or more, or a THC concentration of 5 nanograms per milliliter of whole blood or higher within 2 hours after driving. Submit to a breath or blood test upon the reasonable request of a law enforcement officer. If the Department of Licensing determines that you need to have an ignition interlock device installed on your vehicle, you need to make sure you follow that. Have no criminal law violations. I'm going to put you on monitor probation for the 2 years, which means you're not going to have to meet with probation. That's because you've done everything that you need to do. I've got everything in the file, but I'm just going to put in here that everything get filed within 15 days, but I'm noting that I saw everything in there, so there's nothing more you have to do. And so that I think is everything. Do you have any questions for myself or your attorney prior to me signing this document, sir?
I don't, Your Honor.
Okay.
Yes, where do I send the
All
thank
right.
you?
And Mr. Buck, anything further?
Campaign donation.
No, that covers it. Thank you so much, Your Honor. Thank everyone.
All right. I've gone ahead and signed this, Mr. Crum. Good luck to you, sir.
Okay, thank you.
Thank you, sir.
Thank you.
That's his third.
Okay.
And he got off with like, I just have to slow down.
Your Honor, I think Valley just has one more matter, and that would be Terry Hartness.
Okay. I see a motion to continue here. Okay.
Good afternoon, Your Honor. Whitney Gardner appearing for attorney of record Jenna Henderson. This is a defense motion to continue. This is our first contact with Mr. Hartness since being appointed to conflict counsel. I had the opportunity in a private and confidential breakout room to go through the motion to continue. I got updated contact information for Mr. Hartness, and I sent him a text message on how to get a hold of Ms. Henderson. He authorized my signature on his behalf.
Thank you very much, Ms. Gardner. Mr. Hartness, are you able to hear me?
Yes, I am. Loud and clear.
Can you take off your hat?
Wonderful. Do you understand what's happening here today, sir?
Yes, I do. She's very thorough.
Oh, fantastic. And do you have any objection to the continuance?
No, not at all. Thank you very much.
Okay. Mr. Johnson, any objection to the continuance, sir?
No objection, Your Honor.
All right. I'm going to grant the motion to continue. I'm going to find good cause and an excluded period. So your next court date is going to be August 31st at 1:30 with a tentative trial date of October 12th. If you ever have any questions about anything, make sure to contact your attorney. Okay, sir?
Okay, thank you. I'll write that down multiple times.
Perfect. Thank you, Mr. Hartness. Have a good day, sir.
Hey, you as well. Likewise.
Mr. Hartness, be safe. And Your Honor, I think that would conclude the Valley matters today.
Thank you, Ms. Gardner.
Bye. Nice to see you.
Nice to see you as well.
Thanks, Mr. Johnson.
Good to see you too. Thank you.
Goodbye, John Boy. Yeah. That was a long farewell.
Okay. That's fine. I'm happy to, let's see, I think people are probably in breakout rooms right now. Yep, I think they are. Okay, that's fine. I'll just turn off my camera and my thing and you just let me know, okay?
Sounds good. Thanks.
Thank you.
This is an easy court. I've seen people show up for Arts Beats and Eats parking violation. They got hit harder than those DUI and impaired cases. Can you imagine if somebody walked in Simpson's court wearing a hat, sat through that? No, Your Honor, I prefer to keep my hat on. That's fine. I'm good. Thanks, though. Thanks for asking. Yeah, that was a pretty interesting court. Thanks for sending us there. Whoever gave us the tip on that one. If you have another one, we'll poke around, see if there's something else we can see. See if maybe that influenced the algorithm. Looks like Thurston County's up. What's up in Thurston County? What are we doing up there?
And I'm going to reset the case for confirmation and trial.
Got Nisqually.
Voy a volver a poner el caso para confirmación y juicio.
And I'm going to ask the attorneys to tell me if these dates don't work for you, but I'm looking at September 2nd for trial.
Voy a preguntar a los abogados si estas fechas no les funcionan. Estoy mirando a la semana de septiembre 2 para juicio.
And trial confirmation on August 24th.
Y la confirmación para juicio en agosto 24.
That is a brown trout on the calendar of Mr. Lorenzo Leone.
Oh, on Thursdays?
Yeah.
Okay.
Could be a char. They're related to char.
All right,
It's
Mr.
actually not in the
Leone.
trout family.
Are those dates going to work
Sort
for
of
you?
looks like a brookie too, though. Just can't see. It would need
What time on 8/24, Your Honor?
¿A qué hora? El 24 de agosto.
Time would we do that? Yeah.
That would be 10:30.
Okay. That would be 10:30 a.m.
I think the Lacey
10:30.
girl is
We will be there,
casting
Your
a
Honor.
hex on the
Sí.
judge right now.
Estaremos ahí.
Your Honor, the trial dates were what again, Your Honor?
September 2nd and 3rd.
Los días de juicio, septiembre 2 y 3.
I think that's fine, Your Honor.
Sí, está bien.
Right. That will be the order of the court.
Esta es la orden del tribunal.
And Mr. Leone, I invite you to calendar the misconduct issue, the mismanagement issue with calendaring.
Señor Leoni, le invito a que por favor usted ponga ese asunto del mal manejo, lo de la conducta, con el calendario.
Understood, and thank you for the court's time.
Gracias.
You understood
Your
the
Honor,
Spanish?
I'm just going to put this on the record. I respect the court's ruling. I'm just objecting to release given his history. I'm sure you understand that this is his 5th lifetime DUI. He was originally, sorry.
Bueno, estoy objetando, respeto el fallo que ha entrado hoy el tribunal, pero quiero poner mi objeción a que a él se ha puesto en libertad, ya que este es el 5º que tiene de DUI en su vida.
And given that the court has at least expressed on the record that it doesn't seem the city did anything wrong here in terms of government mismanagement.
Y
We
debido
would
al,
just- Go ahead,
y, de-
go ahead.
y debido al hecho de que el tribunal ha dicho hoy aquí en las actas que la ciudad no estuvo en lo equivocado aquí en relación al mal manejo por parte del gobierno,
And we are just objecting based on a danger to the community standard, but I do respect the court's ruling.
estamos objetando basado en el peligro a la comunidad, pero claro, por supuesto, respeto el fallo entrado por el tribunal hoy.
All right, thank you.
I think Lacey, the
Gracias.
center,
all
might
right.
have some mental health.
Mr. Castro, you'll be released with those conditions as I explained, and please contact pretrial services and your attorney immediately.
El señor Castro Mesa va a ser puesto en libertad y por favor, con las condiciones que he explicado, por favor contacte con los servicios anteriores al juicio y con su abogado inmediatamente.
Bye. says
Una
Leone.
pregunta, ¿tengo que mañana ponerme el aparato?
Si tiene que, ¿qué? Perdón.
A ponerme los aparatos de las condiciones para la libertad.
The conditions of release.
¿Cuál fue su pregunta? Disculpe, es que no le oí bien.
Que si tengo que ponerme los aparatos que me pusieron como condiciones.
Okay, so I do have to get those devices or device that you input as conditions.
That's correct.
¿Cuándo
Sí, señor.
tengo para ponerlos?
When are they gonna do that?
Immediately.
Inmediatamente.
¿Podría obtener direcciones?
Will I have the address to do that or something?
Yes.
Sí, señor.
It's
No se
where you
apure.
live right
I will
now.
call you
That
now.
information will be given to you as soon as you step out of that room.
Tan pronto como salga de ese cuarto, señor, le van a dar toda esa información.
Salgo, si me dejan salir hoy, salgo a las 7. Yo creo que ya no sé si estén abiertos. Sería
Well,
la primera hora.
if they let me out today at 7 p.m., I don't know if they're going to be open.
Then we won't let you out. at 7
Mr.
p.m.
Leone, would you be good enough to meet with your client as soon as he's released so that he can have this explained to him?
Por favor, señor Leone, si usted se puede encontrar con su cliente tan pronto como lo pongan en libertad para que usted pueda explicarle todo esto bien.
Yes, I will speak with him and his family.
Sí, voy a hablar tanto con él como con su familia.
Thank you.
And Your Honor,
Gracias.
just as a point of order, do you want me present at any hearings on that motion to, as far as I understand it, I'm essentially would just be coming in as a witness to explain the timeline and things from my side, but I don't know if the court requires that, me to come in as a party, or I just want to do what's best for the court in this situation.
Solo para temas de logística, estoy preguntando si para las próximas audiencias usted quiere que yo esté presente. No sé básicamente si a mí se me va a llamar como un testigo para explicar la línea de tiempo de todos los eventos sucedidos. En realidad no lo sé, entonces si el tribunal lo puede aclarar.
Only if Mr. Leone or Ms. Vitale want you to.
Solo si el señor Leone o la señora Vitali así lo requieren.
Understood, Your Honor. Thank you.
Gracias, entendido.
All right, we're going to switch over to Nisqually Lacey now. Ms. Garcia, thank you very much for doing that for us.
Thank you. Bye-bye.
Ms. Hawk, correct?
Yes.
Okay. And Ms. Grisco, you have Ms. Hawk's case?
Yes, Your Honor. This will be for a change of plea that will then go into open sentencing.
Okay, and that's on the assault charge under the 143 case number?
Yes, Your Honor.
And then both show cause matters as well, Your Honor.
Okay, and Ms. Hawk, I have your guilty plea here, and it's to the charge of simple assault. Have you reviewed your guilty plea statement with Ms. Grisco?
Yes, Your Honor.
2.5
Now
hours
you're
in on
waiving your
deliberation.
legal rights by entering a guilty plea. So you're giving up the right to take the assault charge to trial and have the prosecutor prove that charge against you beyond a reasonable doubt to a jury. The right to call your own witnesses to court who could testify in your defense. The right to hear and question the witnesses who would testify against you. You're giving up the presumption of innocence on the charge and the right to appeal your conviction to a higher court. The maximum sentence is 364 days in jail and a $5,000 fine. And even though I will hear recommendations as to sentencing, you need to understand I'm not required to follow anybody's recommendation and could impose any sentence up to the maximum. And Ms. Hawk, did anybody make any threats or promises to get you to plead guilty to assault? And written here on your plea form, it says on or about May 29th, 2026, in Lacey, I intentionally assaulted Brian McKagan, which resulted in bodily harm. Is that your statement?
Yes, Your Honor.
Did he deserve it?
All right, I will write here on the guilty plea that you're adopting this statement because your signature does not appear on the document. And I will also find that as factually sufficient and accept your guilty plea. All right, Ms. Eddy, then can I hear from the city as to your recommendation?
Yes, Your Honor. And I guess my remarks were to address all three cases because Ms. Hawk is also on probation with this court for 5A05388988, which was a malicious mischief case from October of 2025, as well as another assault case from April of this year, case number 6A0242. 955. On the malicious mischief case, she has, my calculation is 347 days of suspended time remaining. And on the assault from a few months ago, she has 342 days remaining. I guess I'd like to first give the court a brief summary of Ms. Hawk's out-of-state criminal history, because the court may not be aware of that. So she has out of Utah a 2019 aggravated assault conviction. She also has from North Dakota a 2015 assault conviction. When I look at her other cases, combining that with her Washington convictions, that makes this now her 6th assault conviction. Additionally, out of North Dakota, she has a rather old contempt of court conviction for failing to appear also back in 2015. And her other convictions out of Utah or 2024 firearm possession purchased by a restricted person, a 2013 theft of a firearm or inoperable vehicle, 2023 retail theft, 2019 DUI and obstructing, as well as malicious mischief and theft by receiving and stolen property also in 2019.
Round, get around.
The city is asking for a harsh sentence today because, quite frankly, Ms. Hawk, we have tried the rehabilitation approach with Ms. Hawk and been unsuccessful. In her malicious mischief case, which, just to give the court a factual background, a gentleman had picked her up and given her a ride. She seemed to be intoxicated. He decided he didn't want to have her in the car anymore. He stopped at a 7-Eleven in Lacey and was trying to get her to get out of the car because he didn't want her in the car anymore. He took her bags. She didn't want to get out. He took her bags, put them to the side, and she slashed one of his tires. And then ran away from the scene. And when she was found and apprehended, she had 6 knives on her person.
6.
The second assault case involved an employee at Ace Hardware. The employee observed that she was trying to conceal items on her person in the store. The employee asked Ms. Hawk to leave the store. Ms. Hawk was resistant to that. At one point, the security person kind of kept following her as Ms. Hawk was trying to walk out the store. Ms. Hawk turns around and tries to push her. She misses. Ms. Hawk kind of spins around again, tries to go to the exit, but then turns around one more time and punches the employee and hits her on the side of the face.
Right in the schnoz.
On the malicious mischief case, she was, because it was the reporting party had indicated that she was intoxicated, so her first sentence in that case had a component of substance abuse treatment, which she never successfully completed. The next case, we tried something new. We tried a mental health component. And again, she was not successful and never complied with that agreement. So quite frankly, it's Lacey's position. We've tried substance abuse issues to address it. We've tried mental health, and she hasn't followed through with either of those. So the current assault case is that Fred Meyer, it happened at Fred Meyer and Lacey, and Fred Meyer was close to closing for the evening. Ms. Hawk was trying to get into the store. 2 security officers were like, "Good night, go on your way, you can't come in." And on the video, you can see it. She just hauls off and swings and punches one of the security officers. I think that given her assaultive history and the fact that she committed this act while on not one, but 2 different district court cases, warrants a significant punitive sentence. So the city is requesting that all of her remaining suspended jail time on the malicious mischief be imposed. So that's 347 days. On the new simple assault case, the city is asking for 364 days with, I was going to ask for 90 days, so 274 suspended. And we'd ask that that be ordered to run consecutive. As to the other case, the city is not asking for any additional sanction on the April 2026 assault conviction. I think Ms. Hawk continues to pose a danger to this community when she shows complete disregard to the personal safety and is assaulting these people that she doesn't even know, and she refuses to address her treatment issues. Thank you.
She wants to address something, though, Judge, if
All
you can
right,
give her a minute.
Ms. Grisco, what's your recommendation?
Yeah, Honor, the city is asking the court to impose an extended consecutive sentence, and the defense is asking you to reject that and approach and instead exercise the full independent discretion granted to this court under RCW 9.92.080 subsection 3. Ms. Howe is competent, legally responsible, and the defense is not asking you to just excuse her conduct. However, her mental health is a critical mitigating circumstance. It explains the recurring nature of her behavior, and it demonstrates why additional consecutive incarceration will not prevent it. She's already served 60 days in custody, wants to move forward with her life. Her housing is up in the air, and she is in therapy with Melina online therapy, and she's wanting to continue to do that. But she's been in custody for 54 days and hasn't been able to continue with that. Previously, she indicated to me that the mental health support that she had was not the right medication. And now that she's gotten off of it, she's reported that she's feeling better, more stabilized than she had in a very, very long time. So we're asking for a 60-day sentence with the credit for the time that she served to run concurrently with her probation sanctions for 60 days each. An extended consecutive sentence is a dead end. It's flooding a vulnerable defendant with massive stacked jail time, and it's not going to improve public safety, nor will it address the underlying mental health crisis driving her behavior. Our proposal is the only one that balances immediate accountability with practical court oversight. And so we ask the court to keep her on the active probation on her older two matters. One, the most recent one will end in April of 2028. Given the multiple overlapping probationary terms will create an administrative trap for repeated violations without advancing rehabilitation. So we're asking for the court to do a 60-day sentence, to impose 60 days on each matter, to all three run concurrent, where it will allow the court to maintain oversight of her, and then also address the behaviors that are causing these incidents. Thank you.
All right, and Ms. Hauk, would you like to tell me anything before I sentence you?
Yes, Your Honor. I've had ample time to sit here while being in that penitentiary to think about how I've behaved, and I'd also like to let you know, since she did take the time to go into some of the situations that have occurred in the past. And granted, most of the situations she brought up have occurred in the past over 10 years ago. Like, I'd like you to keep that in mind. The most recent ones, I personally am not. I grew up here when I was like a little kid, like till I was like 4, and then I moved. Okay, I came back thinking I could get to know my distant relatives. They turned out to be unhealthy to say the least. They were not good supports for me. They were borderline abusive and sexually inappropriate. That put me out on the streets being here. So some of the situations I have been in have not been the healthiest. The one with the men in the night, where I was picked up with 6 knives and I stabbed a tire. I felt like stabbing a tire was better than having those men chase me down, because the situation in the car was not presented to the officers in a true way.
It was self-defense stabbing.
No, I don't feel that I'm a public danger. I feel that when I am not with the right support system, I get myself into situations where I have to defend myself. The security guard, yes, it looks like I just punched him in the face, but he said, "I'll fuck you later," and that really upset me, and I punched him in the face. That wasn't right, and I know that, and I'd like to ask the judge clemency for my behavior. I have a temper, and I have self-respect. I've been put out online in some really disrespectful ways, so I get certain men who have been on certain sites that I wasn't aware of treat me certain ways just out of the blue, and I react very negatively when people disrespect me in a sexual manner. And so it looks like a more habitual, it looks like a habitual behavior, but Your Honor, I do not like behaving like this, and I just ask your clemency in these regards, and I would ask that you put me back on probation and give me one more chance. Thank you.
Okay.
She had a.
All right. Well, Miss Hauk, your situation is difficult because this is your fourth assault conviction here in Thurston County in the last year, and the prosecutor has informed me that there are other out-of-state convictions also for assault. We have placed you on probation 3 times in Thurston County in the last year in order to try and address what the attorneys consider to be problems that you have, underlying issues that you have that might contribute to you committing these crimes. And they've been given to you as probation conditions: mental health treatment and drug and alcohol treatment. Now, you haven't followed through and completed those, and to any extent that you may have participated in them, they have not resulted in you changing your behavior, because you were assaulting somebody 54 days ago, the last time you were out in the community. Now, Ms. Hauk, the prosecutor is correct. That merits a strong response. The city of Lacey has an interest in the community being safe, and the city of Lacey has a lot of cases and a lot of responsibilities. A lot of people come to jail multiple times because they violate the law. But what's important is how they violate the law and what the impact is on the community. Now, it's one thing if a person is doing something like trespassing or, things like that that don't involve physical crimes against persons. But your crimes are physical crimes against persons. You're hurting people, Ms. Hauk, and you don't have any. Ms. Hauk, you need to let me do my part here, okay?
Simply Nikki, thank you for 17
had your
months.
chance to address the court, and I'm going to ask you not to interrupt me, but I won't ask you a second time, okay? Now, your behavior here when you're committing these crimes is hurting people in the community, and that's why the prosecutor has asked the court to impose a severe punishment, or a comparatively severe punishment. Now, I'm going to add to that in addition to the crimes that have been outlined here, and in addition to the reasons that I believe it's appropriate to put you in jail, you're also wanted by a couple of other jurisdictions on warrants for unresolved crimes, including some felonies and including other violent crimes. I don't think it's realistic to believe that you're going to be available to complete probation in the community until you address those other charges that are still pending against you. So you're not appropriate for probation for multiple reasons that I've outlined here. You've asked me to put you back on probation. You've explained to me why you think that would work for you. However, I'm rejecting that because it has failed. It has failed recently. It's failed repeatedly. And I don't believe you're going to be available for probation because of other obligations you have to other courts around the state. So I'm not going to put you on probation for this current offense. Instead, your sentence for the current offense will be 364 days. You have credit for 54 days served on this offense. That leaves 310 days to serve on this case. Now, you've got 2 other matters before the court currently that you're on probation for. With regard to number 6A242955, assault, there are 342 days that remain suspended on your sentence. I'm going to revoke 42 of those days.
Puts you back up to a year.
Oops. 42 of those days. And you'll serve that in addition to the 310 days that you were ordered to serve on the current case. So that's a total of 352 days of custody. With regard to your probation on 5A 538988, malicious mischief, in light of the length of your sentence and the length of your probation violation, I'm not going to impose any additional probation violation time. Now, probation will continue on those cases until it expires, which is to say that when you get released, you're still going to have probation obligations that you're going to have to complete. All right, that is the sentence of the court. And that will conclude your case.
Oh, she slapped.
So 988 is just PR.
She's not taking that one well. She got up before he excused her. She slammed the door and is screaming in the cell block. She may.
All right, we're going to switch over to Nisqually Olympia now, sir. What's your name, please?
James Rice.
James Rice. Okay, I think we have Olympia and Lacey cases for Mr. Rice. Okay, so this was set on for me to handle probation sanctions. Looks like
snowboards in the background.
Lacey has
probation.
One case, and Olympia has.
If you can't get a hold of him, you know where he is. He's on the mountain.
We hear
shredding
from
that fresh
Lacey
powder.
first.
Yes, Your Honor. As I'm pulling it up, I don't remember if this was Miss Langley's case or not. I just remember she had one on this afternoon. Let me pull up Mr. Rice's case.
On the 942 one is Lacey.
Well, okay, I guess it's not.
The last attorney who appeared on the record with him was Mr. Swenson.
Mr. Swenson, okay, I must be getting it just confused with one of the other ones. Yes, Your Honor, I guess before the city made a recommendation, I wanted to hear from probation first. I think I saw Mr. Rosario on there.
Yep, Mr. Rosario, you want to fill us in?
Tell us about the snow report.
Yes, Your Honor, there isn't much to say about this case. He was referred to active probation recently.
I just didn't realize that I was supposed to actually go to probation.
Mr. Rice, don't interrupt Mr. Rosario or anybody else,
sorry.
okay?
I'm sorry, sir.
Yeah, so Mr. Rice was referred to probation on June 15. He was told in court that he had to report to probation within 48 hours. He's homeless. He has provided no contact information to the court, so there is no way he could have been reached by probation. For what I'm seeing and what I'm reviewing, he has a long history of different offenses like malicious mischief, delivery of drug paraphernalia, possession, trespass. So with that being said, probation is just going to defer to the court on the sanction.
Okay. And so Ms. Eddy, on the city case, what's your recommendation?
Yes, Your Honor, I think the city would recommend a 2-day jail sentence as a sanction.
2
days?
Yes.
Okay. And Ms. Grisco, what are you recommending?
Your Honor, recommending him to be out because I talked to him about going to St. Peter's for him to do his evaluation. He said he doesn't have stable housing, doesn't have a phone. His mailing address is general delivery, so that it is difficult for him to get to probation, but we discussed where it is, how to get there. So asked so that he can get to probation, get his evaluation, and get started on the conditions that the court had ordered him to do. Thank you.
All right. And tell me if I'm wrong here, but I think he came into custody on this latest time on July 14th.
That's correct.
Sounds right. Okay. All right, let's switch over to Olympia then. You've got 3 matters on. Mr. Osaro, is there anything in addition to what you told me in the Lacey cases?
Well, the only additional thing I forgot to mention, Mr. I has been with the court for over a year, and there is no proof of substance use assessment or no proof of uh, probation meetings or anything like that. So there's some lack of motivation over there by Mr. Rice.
All right. And Mr. Rusnak, what do you recommend?
Your Honor, I would just ask the same thing, basically time served, certainly with the admonishment that he gets re-referred. He's representing, he wasn't aware of it. In any case, whether he was or he wasn't is really a moot point. He needs to take care of it. I think just give him a reasonable time upon his release to check in with probation and get back on track. With the understanding, obviously, that he's getting a moderately light sanction at this time, but the obligations don't go away with the sanction. He's still got to do it.
That's right.
Okay. All right. I think the cleanest way to do this for Mr. Rice to keep him focused and to manage all the administrative aspects of this is with regard to the Olympia cases, which are charges of possession and trespass and pedestrian interference, to close probation on those. Those cases are older anyway, like back to 2024. So, Mr. Rice, I'm not going to impose any additional sanctions on those, and they'll just be closed.
All right, thank you.
Okay, and then we're going to get to the Lacey cases here in a second.
May I ask, just because I need to be clear for my notes, are you closing the cases completely or just taking them off active monitoring? I'm not.
Completely.
Okay, thank you, Your Honor. I just didn't need clarification. I appreciate it.
Okay. And then, Mr. Rice, moving back over to your Lacey cases, I'm going to apply the 7 days that you've served as your sanction for probation violation in that case. That's the Lacey malicious mischief case.
Okay.
And then now that you've served the 7-day sanction, you'll be released to report over to Mr. Rosero at probation and continue and comply with your probation conditions.
All right.
So on case 942, Lacey, it looks like there are 347 days suspended. On post 7, leaving 340 suspended and re-refer to probation. So then, Mr. Rosero, you'll just be supervising him on that malicious mischief case.
Okay.
Sure. One quick reminder for Mr. Rice, if he doesn't report by the end of July 24th, I'll be requesting a new warrant and I will be making a recommendation to the court next time.
Okay. Thank you, sir.
Okay. Good luck on that then, Mr. Rice.
Okay.
And Your Honor, if I could clarify then just in regards to the Lacey criminal trespass case ending in 4793.
That case is just on because he has that case. There's no hearing scheduled on it, but it looks like there are no affirmative conditions in that case is due to run probation through October of this year.
Okay, thank you for clarifying.
Okay. All right, good luck, Mr. Rice.
All right, thank you, sir. Thank you, folks.
And now we'll go over to Nisqually Lacey. And sir, what's your name, please?
Ayden Anderson.
Anderson, okay. All right, and Mr. Anderson, today you're here in court for your arraignment. This is a charge of attempted theft. The city of Lacey alleges that occurred on July 16th. All right. Ms. Crisco?
Thank you, Your Honor. I spoke with Mr. Anderson about his rights. He's confirmed that he understands them. We'd like to waive formal reading, stipulate to probable cause for this hearing only, and enter a plea of not guilty. In addition, in talking to him about his finances, he does qualify for a public defender. Thank you.
All right, Mr. Anderson, I'll appoint Pacific Point to represent you in this case and enter your plea of not guilty to the charge. And then what's the city's recommendation on conditions?
Your Honor, the city, well, he did fail to appear when we tried to address his probation issue. At this point, the city's not going to oppose him being released on his own recognizance. We would ask for conditions of no violations of law and not to have any contact with Anita Noe, N-O-E is how you spell the last name.
Okay. Any objection to that, Ms. Crisco?
No objections, Your Honor.
Okay. All right, then, Mr. Anderson, you'll be released on this case. Conditions are don't violate the law, don't have any contact with Anita Noe, and then I'll have you come back to court for your pretrial hearing and probation hearing at the same time.
Thank you.
All right, it'll be on August 24th at 8:30.
Thank you very much.
You're welcome. Get that on both of these here. They're what? Are they? All right, and we'll go over to Nisqually Olympia now. What's your name, please?
It's Ashley Gimbert.
Yep. All right, and this is your pre-trial hearing, Ms. Gimbert.
Hello.
Okay, and Mr. Rusnak, I believe that you represent her on all three of these matters.
All right. Yes, Your Honor, that is correct. And Ms. Gimbert, there'll be a change of plea on the older two cases and the 2026 case. In exchange for those pleas, the city will be dismissing the most recent case, which is the obstructing case.
Okay. Number 558.
Okay. Oh, I'm sorry. Yes, I should have said that.
That's correct, Your Honor.
I've got those
3
guilty
hours.
pleas here. Just a second while they open up.
3 hours on the deliberation timer. Are we concerned? This was a 2-day case.
All right. So, Ms. Gimbert, do you want to
per
plead
day
guilty
normally.
to theft in the 3rd degree?
Yes.
And to failure to obey a police officer, criminal trespass, and driving while suspended in the 3rd degree?
Yes, Your Honor.
Have you reviewed your guilty plea statements with Mr. Rusnak?
Yes, I have.
Now, by entering a guilty plea to these 4 charges, you're waiving your legal rights. So you're giving up the right to go to trial on them, to have the prosecutor prove each charge against you beyond a reasonable doubt to a jury, the right to call your own witnesses to court to testify in your defense, the right to hear and question witnesses who would testify against you. You're giving up the presumption of innocence on these charges and the right to appeal your convictions to a higher court. Okay. Now, for the charges under the 131 case number, failure to comply with police, trespass, and driving while suspended 3rd degree, for each count, the maximum sentence is 90 days in jail and a $1,000 fine. For the charge of theft in the 3rd degree, the maximum sentence is 364 days in jail and a $5,000 fine. Regardless of any sentence anyone recommends I give you, I could impose up to the maximum sentence for each count. Now, Ms. Gimbert, did anyone make any threats or promises to get you to plead guilty to these charges?
No, Your Honor.
All right, and I'm going to look here first at the charge of theft, and the statement you provided here says on March 23rd of 2025 in Olympia, I stole merchandise valued at less than $750 from Target with the intent to deprive them of it. Is that your statement?
Yes, sir.
Okay. All right, with that theft charge, I'll accept your plea of guilty. And then turning to the other three counts, the statement you provided here says, in Olympia on February 15th of 2025, I failed to pull over for a traffic stop by a marked car after continuous deployment of sirens, emergency lights, and verbal orders to pull over
was a
by a
pursuit.
police car PA system, and unlawfully entered the property of 1100 Plum Street after being trespassed. All right, is that your statement?
Yes, and I did pull over to the Rosie's place, the young adult shelter, which is where I was stopping. So the officer saw me signaling, but he didn't know what I was signaling at. I wasn't intentionally running, but I do plead guilty to not stopping when I was supposed to.
All right, and at the time you were driving that car, was your driver's license suspended?
Yes, Your Honor.
Okay. All right, I've added that language to the statement so that it's clear you're
My
also
apologies, Your
pleading
Honor.
guilty.
I failed to put that down. It was discussed. I'm
Not
sorry.
much room to put it on there. Okay. Then with regard to those three counts, I'll accept the guilty plea as well. Okay. Ms. Vitale, anything else from the city with regard to sentencing?
I'll just say, Your Honor, it's an agreed recommendation. If you look at the defendant's criminal history, it looks somewhat lengthy, but there's really only two convictions, one for a theft charge and an obstruction charge. Yes, they are recent, but I think given the totality of the history here, I think this is a good resolution. I think it is fair, and I would just ask the court to follow it. The city has not had a chance to sign that plea form. I believe it was sent to the court this morning, so the city's just acknowledging that we do support that recommendation in the plea form. Thank you.
Okay.
For the plea forms, because there's two.
Right. Okay, Mr. Resnick?
Thank you, Your Honor. Yes, basically the same thing. This is a negotiated and agreed global resolution for all the three cases, including the dismissal on the last one. We respectfully ask the court to follow it.
All right, and Ms. Gimbert, do you want to say anything before I sentence you?
No, sir. Thank you.
All right, well, Ms. Gimbert, I will follow the recommendation. So for the theft charge, the sentence is 364 days, 351 suspended, credit for 13 served, so you're eligible to be released. There'll be no financial obligations. Then for the next 2 years, don't violate the law.
Yes, sir.
2 years. Keep your nose squeaky clean during those times.
And on the 131 case, count one, failure to comply with the police. That'll be a sentence of 90 days with 74 days suspended and credit for 16 served. Count two, trespass, 90 days with 90 days suspended. Count three, driving while suspended, 90 days with 90 days suspended. You're eligible to be released on that case as well. There will be no financial obligations. And for the next 2 years, the conditions of your suspended sentence: don't violate the law and don't drive without having a driver's license and insurance.
Yes, Your Honor, thank you.
And then the last issue is just case 2026558 obstructing. That count is dismissed and you'll be released on that case as well.
That's a pretty good outcome for you.
All right, you're welcome, Ms. Gimbert. Good luck to you.
Thank you, Your Honor.
Be here with her. Thank you, Your Honor. I'm just going to make sure I have all her orders so they'll be able to release her.
Who am I covering up here? New person, who dis? I have to move down.
Okay, switching back over to Nisqually Lacey. Ma'am, what's your name, please?
We're going to watch for another 9 minutes, see if we get a verdict. And then we're going to wrap up for the day, which will cause a verdict.
Believe.
Believe?
Believe fight.
That's your first name.
Yes.
Okay. Got it. Okay. And today you're here in court for your arraignment. The charge against you is physical control of a motor vehicle while under the influence, and the city of Lacey alleges that that occurred on July 21st. Ms. Crisco.
Thank you, Your Honor. In talking with her about her rights, she's affirmed that she understands them. We'd like to waive formal reading, stipulate to probable cause for this hearing only, enter a plea of not guilty. And we do represent her on her other matters, and her status has not changed. So we'd ask to be appointed on this matter as well. Thank you.
Okay. All right, I will enter your plea of not guilty and appoint Pacific Point to represent you on this newest charge as well. All right, and then Ms. Eddy, what's going to be the city's recommendation on release?
Yes, Your Honor, and so
is blank. Sorry, go ahead.
No, that's okay. So the Ms. Feet's other case with this court is a DUI case from June 26, where she was PR'd. So I did give the defense counsel a head up that I'm going to make an oral motion to revoke her release on that case, T00555125, for violating her release conditions by consuming alcohol and committing a new law violation of physical control. The breath alcohol content in her newest case is a 0.146, and this is a month after having been released by this court on her own recognizance. So the city is asking for $10,000 bail on each case, given the fact that she is a danger to commit the violent crime of vehicular homicide, and also risk at failure to appear. I note when we ran her NCIC today, it appears she has an outstanding warrant for failing to appear out of Oregon for a misdemeanor case with 2 counts of harassment, as well as 1 count of interfering with public transportation. So she appears to have absconded from Oregon and now violated her release conditions and continues to pose a danger to the community. Additionally, the state's requesting the city require that she have SCRAM installed before she's released, and also that she be required, I think, as mandatory under statute, to have an ignition interlock device installed with all the other standard DUI release conditions.
Ms. Crisco.
Your Honor, we would ask for her to be released on her personal recognizance. These are allegations at this stage. As for the Oregon matters, she is in Washington. She doesn't have any family that can help her get down to Oregon. She is currently not working, so she's having a hard time getting down to Oregon to deal with those matters. Instead of SCRAM, she indicated to me that she has a very her body's fairly delicate, is how she described it. No opposition to the ignition interlock, but instead doing a pretrial service release where she would be subject to random UAs by probation. That would enable her to be released, to make sure that she is being supervised and the court can still monitor whether she has any alcohol in her system. And the other standard DUI conditions are not being objected to either. Thank you.
Okay, well, I have to take into account that Ms. Feitz is on pretrial release currently for another similar crime. And in addition to that, the reasons that Ms. Eddy stated about her out-of-state criminal history and I guess the particulars of how the violation occurred. The request for bail is reasonable under these conditions. She poses a significant risk to the public. So bail in each case will be set at $10,000. Conditions of release on the current case will be: don't violate the law, don't drive without an interlock, don't go to bars or taverns, don't drive without a license and insurance, no alcohol, marijuana, or non-prescribed drugs, and don't refuse a breath test. If you do post bail, you're to be on pretrial services supervision and to get a SCRAM alcohol monitoring device at their direction and at public expense. Pretrial for both matters will be on July 27th at 8:30. That was pre-scheduled on the original DUI charge, so we'll keep that as the pretrial date for both cases.
All right,
so
Judge.
That's this coming Monday. All right, we'll see you on Monday, Ms. Fights.
We're gonna bail a little bit here. We are waiting patiently for Judge Raquel West to come back with a verdict. I was thinking we'd have music today, but it's now 6 o'clock. I'm going to be watching. We'll be saving anything that happens. It's going right there. It's active. And if it does come in, we can bring it to you. Might even go live again tonight if it does, but don't think it's happening. Don't think it's happening. When was the last day we had 2 verdict musics in one day? We got one today, right? Or was that yesterday? I forget. All the days are running together. Let's call it a night. Yes, most definitely. It's been a day, so let's call it a night for sure. Oh man, I like Thurston. Thurston is fun, especially when they have their civil cases. When you got neighbors that just can't get along or talk to each other, act like adults, or figure out how to prune a tree appropriately without offending their neighbor. Oh, sorry, that was me. But yeah, it's a lot of fun to go up to watch Thurston. I guess we continue till tomorrow. There might have to be a contingency plan so we can figure out what's going to happen with the jurors. Why am I so small? That was my fault. There we go. I'm growing like Alice in Wonderland. I guess hopefully good weather tomorrow. The juries will figure it out and decide to either to do something or not do something. We come to a conclusion one way or another. Thursday afternoons are a lot of fun. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again tomorrow morning, bright and early, with more out of Judge Raquel West's courtroom. Still looking for that next big trial we're going to go to. I've had a lot of you reach out about this mom trial that's just starting. I just can't do it. I've had so many people say, please, no, I can't do it. And it's tough, not just for you, it's tough for me as well. I'm a parent. And when we have a case where a mom is accused of killing kids one after another, that's rough. That's rough. It's like Letitia Stout times 3 or 4, I think it is. So, you guys be good to each other. We'll figure something out going forward, but thank you all. We'll see you tomorrow. Have a good one. Bye-bye.
Thank you, sir. You're my new best friend.
Because he's the guy.
You don't put a diplomatic plate on a hoopty.
Because we here in Canada hate you and hope for bad things for you because we hate you.